Yes.
Lordship, yesterday I moved in motion, Lordship. There was some typographical error in the pair portion, Lordship.
Ah,
Lordship directed me to file an application, which we have filed yesterday, Lordship. And Lordship has fixed the case on Friday, Lordship, on 27th. So may I pray, Lordship, that I may be listed along with the
on Friday.
Lordship.
Okay.
Yes.
Yes.
So I pray for listing of two urgent petition, Lordship. Yesterday it was filed, Lordship. Matter pertains to promotion to the post of headmaster, Lordship. So what happened here, Lordship, while the district selection committee forwarded the list, Lordship, the junior Lordship, then the petitioner, their names have been recommended, Lordship. And the day before yesterday, Honorable Education Minister also announced that by this month, Lordship, the promotion order will be used. If it is not inconvenient at 2 p.m. Lordship.
Not today. We'll,
Tomorrow.
tomorrow. Okay, tomorrow.
Apply, Lordship.
May I please, your Lordship? My Lord, with the consent of the other side, I beg to mention item number 34, Lordship. Lordship, may kindly take up this matter on 16th of March, Lordship, subject to convenient, Lordship. 17th of March, Lordship, subject to convenient.
For the private respondent here.
34.
Item 34.
There's an office note. What is this?
Yes, it was
Yes,
actually.
it was earlier, it was
Parthead
Parthead.
before the-
Uh-huh.
Now that has been released.
Yes, Kim, can you have it on?
Earlier it was
60?
part heard, Lordship, then it was released, Lordship. Such a-
19th.
19th of March.
Yes, Thursday. It's a hearing date.
Thursday, Lordship.
Thursday, they have some
Lordship,
inconvenience. my
any
lord.
Tuesday, Lordship.
Any Tuesday, my lord, convenient.
17th is possible? All right, 17th.
17th, deeply applied.
Please
Deeply
write as paid for by the learned counsels for the parties. Let the matter be listed on 17th of March, 2026
For hearing.
for hearing.
Deeply applied.
Lordship. Deeply approved.
May I please, your Lordship? I beg to mention item number 3 and 4, due to illness of my senior counsel, S. Sharma. So kindly, as you know, today,
S. Sharma, A. Sharma.
S. Sharma. Respondent number 4 and 5.
I see. Have you informed the other side?
Yes, sir.
Okay, any objection? Mr. S. Sharma, learned counsel for respondent numbers 4 and 5 is said to be indisposed. And on a prayer made on his behalf and not objected to by the other side, matter stands adjourned. To be listed again on so and so.
Why, sir?
Which to Lordship, I beg to mention item number 16, 17, 18, 19, 20,
Yes.
20,
Deep, yeah.
on behalf of Divuya, kindly adjourn this matter for
Yes, what
today
happened? What happened?
and give list on 8 March, Lordship.
I don't know whether it's possible. 8 March is Sunday. You want to come on Sunday?
Lordship,
You want to come on Sunday?
12,
8 March.
7, 9 March here, Lordship here,
Any date? 12 March.
12 March. Always my Lordship.
All right, just a minute. On a prayer made on behalf of Mr. D. Bhuyan, learned counsel for the petitioner, and not objected to by the other side, matter stands adjourned to be listed again on 12th of March, 2026. All right. 16 to 20.
Always.
Lordship, with the consent of other side, I beg to mention item number 8, Lordship.
Item number 8, yes. What do you want?
That's any day after 25th of March.
You're mentioning on behalf of?
On behalf of Mr. D. Upamayya, Higher Education Department.
Okay, no objection from the other side? On the prayer made on behalf of Mr. D. Upamayya, learned standing counsel, Higher Education Department, and not objected to by the other side. Matter stands adjourned to be listed again on so and so.
Authorized.
May I please, your Lordship, with the
Yes.
consent of the other side, I beg to mention item 7
7.
for adjournment.
Yes, what do you want? On which date?
On
And you are
behalf of
for,
people, guys, for-
you are
1
for?
week.
You are for the petitioner.
Yes, your Lordship.
What's your good name?
My name is JP Boro on behalf of B. Purcaster.
Why do you want adjournment?
There is some difficulty on the conducting councils.
Mr. B. Pukasta, learned conducting counsel for the petitioners, is said to have some personal difficulty to appear before the court today. Stop on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned.
Also 35 and 36.
To be listed again on so and so. Alright, also item number
35 and 36 connected.
35, 36. All right, similar ordering item 35.
But in this case, I feel. On
35, 36 on 24th of March.
20, can it be on 20, after 25th March?
All right, 26 then.
20,
Make it 26 March, okay?
20.
Right,
27. Oblige, your lordship.
next.
May it please Lordship. Lordship, I beg to mention item number 9. Lordship, the senior counsel is legs in another court. Kindly fix the matter at 2 p.m.
Matter has not reached also, he is mentioning now on legs.
Lordship,
We wait,
then pass over for time.
let the matter be called. Item 1, 2 is to be called, 5, 6 has to be called. And before that, order matters will be there. You wait. Anyone else?
LLS item 1 to 2 promotion.
Mr. Abedin,
Yes, ma'am.
what is this case?
My lord, your lordship would remember, teacher's transfer order was issued by a deputy commissioner. That is the prime foundation. And secondly, while doing it, they did it illegally because PTR ratio was not maintained. Number one,
Government needs to file a affidavit and get some stuff.
my lord, government filed already. Government already filed. And there is no instruction required, my lord. It was, my lord, on last occasion, it was for disposal, and similar order has been already passed by this honorable court, my lord, only on 6th, on 18th of this month, my lord. May I just hand over the case, my lord? Exactly same, my lord. My lord, if your lordship permits, I'll start from paragraph 3, my lord.
Hmm. Before that, just a minute, who's appearing for the other side?
Government and I'm for the department, I'm looking for government, my.
You're for the department
Yes, I'm for the department.
and
He's for the government.
Tukan is for the,
Will need deputy commissioner.
okay. All right,
None, nobody.
Miss Tukan,
Yes, Your
you
Lordship.
ready?
Yes, we have filed our affidavit. We have mentioned in paragraph number 5, Your Lordship.
Okay, we'll hear you later on. Let me first hear the petitioner.
Yes.
Item, paragraph 3.
My lord, if my friend is ready, then let us give the brief idea, my lord, from the petition itself.
Surely.
Yes, my lord.
How many petitioner? One
My lord, only
petitioner.
one.
What is your grievance?
My lord, my grievance, would your lordship be pleased to note down one date, my lord? 5/8/2025.
Hmm.
Upon mutual transfer, I came to this school.
5/8/25.
5/8/2025.
What is this date? What is the significance?
Yes, my lord.
What is the significance of this date?
That is because when I came, my lord, only about 4-5 months back on mutual transfer, I ought not to have been transferred in this manner
Petitioner transferred to,
to the present school, my lord.
what is that?
That is
Kamarpara.
Kamarpara.
That was on 5/8/25.
5/8/2025.
Okay.
Okay. Now,
Hmm.
the impugned order is 26/12/2025.
Hmm. Page number,
Page number, my lord. My lord, 27 is the typed copy, my lord.
Yes.
Your lordship may underline this first two line, my lord. In pursuance to the so and so, in view of people teacher ratio.
Mm. Yes.
So on this, my lord, my name is 11.
Mm.
My name is 11.
Mm.
From Kamarpara to 1898, Purua Chandanpur LPS.
Mm. So within a span of about 4 months, you've been transferred out. So you're challenging this.
Yes.
Okay.
So, my lord, to cut it short, as
Mm.
there is a decision by this honorable court, my lord, I'll directly bring my lord's attention to this
Page number.
page number, my lord, 15. The act starts from page 8.
Mm.
Page 8 is the Assam Elementary and Secondary School Teachers Regulation, Posting and Transfer Act. Is it,
Yes.
my lord,
Yes.
got it?
Yes, I've got.
Now, would your lordship be pleased to come to page 15, 9. Section 9.
Yes.
Section 9.
Power of Deputy Commissioner.
Power of the Deputy Commissioner. May I read it, man?
Yes.
In case of exigency for maintenance of proper academic atmosphere in a school or for maintaining peace and tranquility or safety and security of a female teacher, the Deputy Commissioner of a district, after observing such formalities as may be prescribed, if satisfied that transfer of a teacher is essential for anyone of the said grounds, may refer to the competent authority for transfer of a teacher even from a low PTR school. The competent authority shall immediately consider such proposals of the Deputy Commissioner and recommended to the concerned appointing authority for issue of transfer order, provided that on transfer of such a teacher from a low PTR school, the appointing authority shall immediately post a teacher in that school to maintain the PTR norms as per provision of the Act, either by the direct recruitment or through transfer from a high PTR school. My lord, over here, it is clear the Deputy Commissioner has the power only give the recommendation to the appointing authority. Now, would your lordship be pleased to come to section 5, that is page 12. Section 5 is the
Yes, section 5.
competent authority for recommending transfer of teacher as per PTR norms.
Mm.
My lord, got it.
Yes.
My lord, I will directly come to 5, my lord.
Mm.
The district level committee, as mentioned below, shall be the competent authority for recommending inter-school transfer of teachers within the district.
Mm.
So the competent authority, what my lord has seen in section 9, this is the competent authority, that is the district level committee. So district level committee is, my lord, these 4 persons. Now, number 6, 5, 6, my lord, got it. The appointing authority shall issue the inter-school transfer order of the teachers within the district on the basis of recommendation of the district level committee on being satisfied that the recommendation is made in accordance with the provisions of section 4 of this act. Provided that the concerned authority, appointing authority as aforesaid while issuing the transfer order shall ensure that no teacher is transferred from the low PTR school to high PTR school except under section 9 of this act. So now my lord would be now posing a question to me that how many students are there in your school and how can you say that the transfer, though it is by the not by the appropriate authority beyond his jurisdiction still. Then I'd like to draw my lord's attention to whether this small there is a small one, is it available or not? Yes,
Page number?
page, my lord, I'm coming to it. It is the Right of Children to Free and Compulsory Education Act 2009. It is the first act in the book, my lord. I'll just bring my lordship's attention to page number 28.
Schedule?
Yes,
Okay.
my lord, before going to this schedule, would your lordship be in the other book, section 4? Section 4, once, my lord, page 11.
Yes, this is regarding that people-teacher ratio.
Yeah, yes. How can I depend on this Act of 2009? It is over here. For elementary school, PTR has to be calculated in accordance with the provisions contained in section 19 and 25 read with the schedule of the Right of Children to Free and Compulsory Education Act 2009. So my lord got it.
Yes.
Yes, this is the one. My lord, over here in the schedule, serial number 1, it is for the LP school, that is for first class to fifth class. Exactly left hand side. My lord got it.
Yes.
My lord, in the middle, up to 60, 2 teachers.
Yes.
So in my school, that is there in the page 41 itself, in the writ petition, the block elementary education officer saying that though it is actually 63, but he said there is a school is having 60. So there are only 2 teachers, me and the headmistress. I don't know when the PTR ratio is required 2 teacher, why I was removed, because there is strict prohibition that you cannot remove and you have to maintain the PTR. And secondly, my lord, the deputy commissioner doesn't have the power. He is directly involved in issuing this transfer order. Now, similar order, my lord, similar issue has come before this court, and as such, I just relied on this judgment, my lord. I would like to start from paragraph 3. The petitioner in the present proceeding has sailed an order of transfer dated 5/1/2026 issued by the District Commissioner Darang Mangoldoi, transferring the petitioner from number 3 Kachari Betitop LP School to number 4 Boruaja Dakshin Suba LP School. The petitioner has projected in the writ petition that the order of transfer dated so-and-so has been issued without jurisdiction by the District Commissioner Darang Mangoldoi. It is submitted that the transfer of teachers of elementary and secondary school is presently regulated by the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2020. It is submitted that the provisions of the said Act of 2020 do not empower the jurisdictional district commissioner to issue orders transferring the teachers working in a school within the area falling under his jurisdiction. It is submitted that the order having been passed without jurisdiction, the same would mandate the interference of this court. The learned counsel for the petitioner has reiterated the said fact and has submitted that the order dated so-and-so having been passed by the district commissioner Darang, Mongoldoy without jurisdiction, the same is null and void, and the direction passed therein to the petitioner would not mandate compliance by him. MS so-and-so learned standing council elementary education department. This is important, my lord. On instructions, has submitted that the power to issue orders for transfer and posting of the teachers working in the elementary and secondary schools is vested in the departmental authorities, including the district authorities of the said departments. She has not seriously objected to the contention raised by the petitioner with regard to the jurisdiction of the district commissioner to pass the impugned order of transfer. I have heard the learned counsels for the parties and also perused the materials available on record. The Act of 2020 admittedly does not empower the deputy commissioner, district commissioner to issue orders of transfer in respect of teachers working in schools situated within the area under his jurisdiction. The district commissioner, in the event of finding any necessity for transferring a teacher so working in a school within the area under his jurisdiction, can make a recommendation with regard to the same to the competent authority of the department, either at the directorate level or at the district level. The jurisdictional district commissioner, in the considered view of this court, would not have a jurisdiction to transfer any teacher from any school to another school situated within the area falling under his jurisdiction. In view of the above, the impugned order of transfer dated so-and-so insofar as it concerns the petitioner herein stands set aside. The respondents have brought on record materials. My lord, then there was another allegation, and then court said you can carry on with that allegation. But as far as the transfer part, the deputy commissioner doesn't have any, district commissioner doesn't. In my case, I don't have any other charge, only, my lord, if your lordship is satisfied with my contention, my lord, then I will not go any further. But if your lordship permits, my lord, how an authority of a district commissioner taken such a egoistic towards a small assistant teacher of a LP school?
What do they say in the counter affidavit?
In the counter affidavit, they only one thing they say, there was a cabinet decision, my lord, in respect of deputy commissioners getting the power of transfer of grade 4 and 3 employees within the district. So they said that is applicable everywhere. We said no.
Are you transferred within the district?
Yes, within that.
With the district?
Within the district.
There's no dispute about that.
No, there's no dispute.
Okay.
So what we said no. As far as the teachers are concerned, it is a 220 Act will imply, and all the other stuff who are directly involved with the deputy commissioner's office, like as your lordship is aware, the BDO, panchayat officers, the grade 3, grade 4. It is meant for that, not for the teachers, because no order or notification will override this statute, my lord. It is under 309 statute. And over here, categorically, it said it has got the deputy commissioner only has the power to recommend before the appropriate authority, that is the DLC. DLC, after considering, gives it to the appointing authority. An appointing authority, in this case, either the directorate of the elementary education or the district officer. The deputy commissioner himself is the signatory of this transfer order.
One more thing is that apart from you are at serial number 11.
Yes.
There are other 10 persons who have been transferred.
They did not come before this honorable court. Possibly they are happy. Possibly they are part of the.
No, that is there, no doubt, but it's not as exercise singly for the petitioner. This exercise has been done for 11 people, including you.
My lord, what I would like to.
So on the other hand, you point out the Act of 2020, wherein the deputy commissioner or district commissioner is only the recommending authority.
That is already held by this honorable court. And most importantly, my department, the department where I belong, they also apprised this honorable court saying that district commissioner doesn't have the power to transfer. That is, as your
All right.
lordship got it in the
All right.
order.
Let me hear the other side.
But only one thing I'll show, why I filed the next writ petition,
Next writ petition means,
item number 2.
oh, there are two matters.
Yes, yes,
By the same person.
same person.
Yes.
Number
Why?
1, when I filed this, which I just now mentioned before my law,
Hmm.
400.
Hmm.
Over there was no private party. There's no private respondent. I said, when I have been removed from breaking the PTR ratio, you have removed me. That means you are going to bring somebody else. So till then, they did not do. When I approached this honorable court, then they have done it. They have brought in a private person. Then my contention, if you are bringing the private person to my school, why did you break this PTR ratio and taken me out? That was the case, my lord, in.
In 8897.
Yes, my lord.
What have you challenged here?
Over here, I challenge both the orders. That is the impugn
The
transfer order,
as well as,
the order passed in favor of this person.
where is that?
Page 52.
52. What is the current status? Has he joined?
No, my lord, I'll just tell you one thing. If your lordship appreciates one thing, my lord. Whenever we see, as a council, my lord, whenever we see this few orders when it is not digitally signed, the doubt crops in, because it happened to me with another case. Over here, I realized that it was 19-1 because they issued an order on 20th where they did not mention about the 19th order. So then I realized possibly this was some hanky-panky, and because then there was no, it was not digitally signed. Would your lordship be pleased to see the first order over here? Page 30 in this petition, man.
Page 30, yes.
Page 30, this is the impugned in the, in fact, in the earlier case as well as this case.
Yes. Yes, what about this?
My lord, would your lordship be pleased to see only one thing? It is 2612-2025. If you see the file number, it is 2025 transfer 41.
Mm.
Your lordship got it.
Yes.
Okay. Now, on 20th, when I filed a representation, that was declined, and this order was issued on 20th January, that is page 45. My lord, just check the date, my lord. It is 20th, 20-1, and see the file number BDD 96/2025 transfer 49. My lord got it.
Yes.
Okay. Now see the last page, my lord. If it is 19th, the file number cannot be 129. It has to be prior to 49.
There's another alphabet after that, A.
No, I did not raise this much because when I say that section 9 is protecting me, I'm showing this. Now, incidentally, my lord, they don't say anything in the affidavit about this. This is gone. Now in the affidavit, I see another person has come in. This which I impugned
Yes.
is no more. And there is not a whisper that this order has been passed. Now in the affidavit which they have filed, I was surprised to see that, my lord, another person has been inducted in my place. That is, my lord, would your lordship be
Another person means?
another teacher? That is page 70 of their affidavit, my lord.
No, another person apart from Anil Boro.
Now Bodo is not in the scene, neither he joined. That was my plea when I filed the writ petition, second writ petition, that one Bodo has been given the appointment, but he has not joined.
Two writ petitions you filed. First one, you challenged the transfer order. Then during the pendency, there's another order was issued. One Anil Boro has been asked to join that place. So you filed the second writ petition. But today you're saying that after filing the counter affidavit, Anil Boro is not in the picture. Another person has come.
Yes. Now see
Who is that?
see their affidavit, my lord, page 70.
Page 70.
Yes, my lord.
Seventy of which writ petition?
Not writ petition, their affidavit. Their counter in writ petition number 400.
Who is this person?
My lord, it seems
Abu Bakr?
Abu
Siddiq?
Bakr. And this is on 12/2. And incidentally, my lord, this order, there is no whisper of Anil Boro. This is only in addition to show to my lord, that a status of the district commissioner in his office. Normally, it is done by the ADC education charge. A small, my lord, assistant teacher of a LP school, how they are behaving with this gentleman, my lord. I don't have a single allegation. They have done it in the name of the PTR, which is illegal, because there were only two teachers you could not have. And next, my lord, the transfer order is beyond jurisdiction, my lord. So I only pray that, my lord, without this, I only showed how they are acting. My lord, this repetition be allowed and the transfer order should be set aside, my lord. And
Okay.
I also depend on this earlier order, which has been, I just said, man.
This Bukan.
In our affidavit, your lordship, page number 57, paragraph number 5, your lordship, I am reading your lordship.
Affidavit in WPC 400.
Yes,
400.
Which is page number?
yes. Paragraph number 5, your lordship. With regard to the statement made in paragraph 10 of the writ petition, the deponent begs to state that the application was submitted by Muhammad Afiq Iqbal, assistant teacher, on 2/1/2026, with a request for stay. His transfer order issued by memo number so and so dated 26/12/2025 from Kamarpara LP School under Senga Education Block to 1898 number Porua Chandanpur LP School under Senga Education Block due to medical condition of his parents and shortage of teachers at Kamarpara LP School. As per Government Office Memorandum, by number so and so dated 25th November 2024, issued by Personnel Department, Government of Assam. I'm reading your lordship. It is well established part of service law jurisprudence that transfer is an exigency of service. Under the terms and conditions of service, an official has no right to remain absent or refuse to join in any new place of posting upon transfer. It is reiterated that all transfers and posting must be given effect by an official under order of transfer without any delay. Any representation submitted by the concerned official against the transfer order will be entertained only after he or she has joined the new place of posting. If transferred official fails to join in the new place of posting timely, strict disciplinary action will be initiated against the official. A copy of office memorandum dated 25/11/2024 regarding transfer is annexed, annexure 1L. In pursuance to the above office memorandum, prayer petition of Muhammad Ashik Iqbal dated 2/1/2026 was rejected, and keeping in view of administrative expediency of posting teacher in zero teacher school, Muhammad Ashik Iqbal, assistant teacher, was directed to join his new place of posting. It was mentioned in the order that the applicant may file a fresh petition after he joins his new place of posting. Further, one teacher, namely Abu Bakr Siddiq, assistant teacher, contractual, is already posted at Kamarpara Lower Primary School under the Senga Education Block in order to maintain pupil-teacher ratio at Kamarpara Lower Primary School, which became a single teacher school after transfer of Ashik Iqbal, and the incumbent has already joined on 13/2/2026. Report of BO Senga Education Block is enclosed. Now, the Kamarpara Lower Primary School is running with 2 teachers. That education copy of BO's report I have annexed here actually. That paragraph number 7, that with regard to the statement made in para 12 of the writ petition, the deponent begs to state that the one teacher, namely Abu Bakr Siddiq, assistant teacher, is already posted at Kamarpara Lower Primary School under Senga Education Block in order to maintain the pupil-teacher ratio at Kamarpara Lower Primary School, which became a single teacher school after transfer of Ashik Iqbal. The incumbent has already joined on 13/2/2026. Now the Kamarpara Lower Primary School is running with 2 teachers. Paragraph number 8, with regard to the statement made in para 13/2/26 of the writ petition, the deponent begs to state that the transfer order by memo number so-and-so dated 26/12/2025 by the District Commissioner, Barpeta, was issued under powers conferred by District Commissioner by government notification number so-and-so dated 21/11/2023, wherein of the approval of Honorable Cabinet as conveyed in its meeting held on 19/5/2023, the Governor is hereby pleased to empower the District Commissioner with the powers of transfer and posting of gazetted and non-gazetted officers posted by the department in the particular district within his her jurisdiction as per the demands of the administrative expediency within immediate effect. In case of transfer of gazetted officers, however, District Commissioner shall have to take approval of the Guardian Minister of the district. The administrative expediency was to immediately post 1 teacher at the zero teacher school, that is 1898 Porua Chandranpur LPS, to cater to the educational needs of 27 students enrolled at that school. That notification I have annexed, Your Lordship, at page number 67, Your Lordship. That notification, Your Lordship, in pursuance of the approval of the Honorable Cabinet as conveyed in its meeting held on 19/5/2023, the Governor is hereby pleased to empower the District Commissioners with the power of transfer and posting of the gazetted and non-gazetted officers posted by the department in the particular district within his or her jurisdiction as per the demands of the administrative expediency with the immediate effect. In case of transfer of gazetted officers, however, the District Commissioner shall have to take approval of the Guardian Minister of the district. This is dated 28/11/2023. Then again, Your Lordship.
Whether this notification can override the Act of 2020, wherein District Commissioner is the recommending authority.
That notification was on 2023.
Correct.
20.
So it is a later notification published later on. But this is a notification by way of an executive instruction. Now, what will happen to the act then?
The department will say all of it.
The act of office meeting is there, madam. Wherever the deputy commissioner is authorized to file a should answer.
Where is that? No, you show me today. You show me now. If you can show me now, no need to file affidavit. Just show me, that's all.
Yes.
No, even if it's a notification, how do you overcome the act? The act provides that the deputy commissioner or district commissioner is the recommending authority for transfer and posting. But here's a case wherein the state authority has issued the transfer order. And you have justified the transfer by saying that notification. Similar matters also decided. WPC number 343, 2026.
My lord, para 8,
Yeah, Lordship, series of matters are there. Your
You
Lordship.
go through now. This is only a
my
two-page
lord,
order.
it was her stand, para 8.
Huh?
It was her stand in para 8. I'm surprised how they can blow hot and cold at the same time.
At that time, it was not even acknowledged by the
Para 8.
power.
No, she got the instruction that was before the court. My friend, my colleague over here, he was present in the court during that period. Paragraph 8 is her instruction before the court. I don't know how she is saying that.
Miss So-and-so on instructions has submitted that the power to issue orders for transfer and posting of teachers working in elementary and secondary schools is vested in the department authorities, including district authorities of the said departments. She has not seriously objected to the contention raised by the petitioner with regard to jurisdiction of the district commissioner to pass impugn order of transfer. This was your submission recorded. No, how he has the power? You show me now. Because we have the book here, the act is there. By way of executive instructions, you may have certain guidelines or whatever. But then the act itself provides that the district commissioner is the only the recommending authority. So, in such circumstance, this act has been enacted. Is it an 309 rules? 309, what is this act? You produce the notification. If you have it now. You don't have to file affidavit. Just show it to me. No, why tomorrow? Are you sure there's a notification?
I'm
Okay.
absolutely sure, my lord. Before this honorable court, I'm saying with full confidence, my lord. There is no such a single notification where it is said the deputy commissioner has the power to transfer a teacher.
In that case, my lord, they may explain.
26.
My lord, 26 is another, I would like to request my lord not to fix it on 26. Those cases are different. I don't want to jumble up the cases.
In that case, whether the deputy commissioner has the power or not, my lord.
It is already decided in this case. Because of them, yesterday the matter could not be taken up on Friday, my lord, last Friday. Otherwise, it would have been finished that day. Earlier that day, my lord was sitting. They took time to file the affidavit, and your lordship said it categorically, if they don't file the affidavit, we will take it for disposal.
No, one day.
On Friday, matter came, they did file the affidavit, but they did not bring it to the court, to the record.
Okay, just a minute. Ms. Sutia, you say there's a notification. Supposing there's a notification, fine. There is indeed a notification. The next question is that whether that notification will prevail or the act will prevail.
Actually, but there's not.
Then
It's in conniving.
how notification will help you then?
That is in conniving with the act, my lord. The notification is passed in conniving with the act also, my lord.
No, we have seen the act provisions, you see, right from section 4, 9, then see, all these things are regarding transfer only.
That act
So,
time and again, remanded.
sorry?
That act has time and again, it was remanded.
No, if it's amended, then you have shown me in the affidavit the position that this is the provision. Why didn't you file it? It's up to you. You don't want to file, we can't wait forever.
Some time maybe.
It's in the motion stage, but there are some cases which has to be considered in the motion stage also. You produce it then tomorrow, if I will see. You don't have to file anything, you just produce the notification, whatever you want to say. Please write down. The short question involved in the instant writ petition is as to whether the district commissioner has the power to transfer the teachers of LP school in the district. While the Assam elementary and secondary schools teachers, open bracket, regulation of posting and transfer, close bracket, Act, 2020, only provides that the deputy commissioner or district commissioner can make such recommendation for transfer on certain grounds to the competent authority. So Mr. J. Abidin, learned counsel for the petitioner, submits that the issue has already been decided by coordinate bench of this court. Provide order dated 18/2/2026, passed in WPC number 343 of 2026. Open bracket. Mohammed Suraj Ali versus State of Assam and 7 others. Stop. He therefore submits that the impugned order having been passed by the district commissioner, the same should be set aside. Next para, Miss S. Sutia, learned standing counsel, elementary education. Submits that there's a notification issued by the state government by which the district commissioner is empowered to make transfer and posting. She submits that she may be given a day's time to produce the state notification. The praise allowed. List again tomorrow.
Tomorrow, my lord.
Yes, tomorrow.
Yes.
One more thing, we just keep this inside.
My lord, will come for motion tomorrow.
I guess it will be motion only.
Yes, ma'am. Deeply obliged, ma'am.
You just clarify that. List again tomorrow in the motion column.
Here, Lordship, on last occasion, I was directed to take instruction, Lordship.
Yes.
Lordship, may kindly turn to page annexer 14, page 42, the direction of the Honorable Court, Lordship. Page 45, para 8. Lordship, the direction there, it is para 8, in view of the above, the writ petition is disposed of by directing the petitioner to submit a detailed representation along with the supporting document before the respondent number 3, that is the director. Lord.
Just a minute, can you keep a sanitizer or something out here? Nearby. Yes, please read.
Yes, Lordship. And para 8, Lordship, in view of the above, the writ petition is disposed of by directing the petitioner to submit a detailed representation along with the supporting document before the respondent 3, that is the director of secondary education, Lordship, within 2 weeks from today, explaining a reason which prevented him from attending the school from 10/9/1997 to 9/8/2000. On receipt of such representation filed by the petitioner, the respondent authority will consider and dispose of the petitioner's representation within a period of 1 month, 3 months on the date of receipt of such representation and by passing a speaking order. So in this case, director was petitioner was directed to file a representation and director was directed to pass a speaking order. That speaking order director has issued, Lordship. Issued long back.
Long back.
Yes,
What is this matter?
This
Content.
regard, that petitioner, he was transferred to a particular school in a BTC area. He could not join in a school for a particular period. And he filed another case for, and court has directed to regularize that period for which he could not attend the school. And to regularize that period for the period of, for the purpose of pension.
You don't have a small one. Okay.
And Lordship, may
So apart from paragraph 8, there's something else in paragraph 9.
Nine
Paragraph
also.
nine.
9 also.
Read paragraph 9
Yes,
also.
if the authorities come to the conclusion that petitioner was indeed prevented from attending the school, the aforesaid period because of the threat perception on account of the various extremist activities taking place during the aforesaid period, as claimed by him, the petitioner would be entitled for salary for the period in question, and petitioner cannot be made to suffer for the reason beyond this control. Yes, Lordship, that director has issued the thing on the affirmative, Lordship. The director has issued the thing on the affirmative that in view of the above, Lordship, the facts and records, Portland may be subject to so and so is may be considered for grant of arrears salary as well as other consequence benefit for the gap period with effect from 10/9/1997 to 9/8/2020, Lordship. Now the government want to, Lordship, after that speaking order issued by the director, Lordship, the government filed an order dated 8/4/2025, directed the director to re-examine the matter in light of the police report and directed the director to get a police report regarding to verify beyond reasonable doubt how he could not attend that particular 3 years of service, Lordship. Now the director is seeking seeking the report from the district, Lordship, police report, Lordship, regarding the authenticity of that for the 3 years he could not join that particular school due to extremist, Lordship, violence, Lordship.
Mm.
So that report is everything. Otherwise, director has already issued the three model. Lordship, can you pay this one? Take on detail.
When was that order issued?
It was in 2023, Lordship.
23.
Yes.
And
And she has recommended that he should given that phase
no, government is directed for re-examination.
re-examination.
When was that?
It was in the 2020, the first letter is in 2025. I have Lordship, 8 for 2025. Then the director has already written to the Superintendent Police Sirang Kazalgaon, Lordship. And recently again, Lordship, she has again written to the SP, Lordship, the present SP, to give a detailed report. In the instruction, Lordship, the first page is a letter from the government that will clear everything, Lordship.
Which one?
In the first page, Lordship. In
Oh.
the instruction, the first page is a letter from the government.
Hmm.
Yeah, I do. And
It's
problem is,
just a minute. It says Director of Secondary Education was
Yes.
requested to re-examine the matter in the light of police report and the petitioner's inability to attend the school must be proven beyond doubt.
that is the government's lawsuit. That is why director has again written to the present SP lawsuit to give a detailed report how that the petitioner could not attend the school for that period of 3 years. Lawsuit.
In this connection, letter from DSC sent to the SP Chirag,
Earlier we have sent.
White
lawsuit.
so and so may be referred to, where police was requested to submit up-to-date status of the outcome of the investigation issued by the then officer in charge, Bijni Police Station, 11/9/1997. So, what is the status now?
Now the director has also written to the present SP again lawsuit seeking a detailed report. Now awaiting that he even telephonically also have a consultation with on yesterday lawsuit with the present SP and requested him to provide that report immediately lawsuit. Otherwise, director has already written to the government in favor of the petitioner lawsuit.
No, that we have understood. Now, you're saying the director has written to the SP. When did he write?
A remind, lawsuit, I have another on 2026 lawsuit. This
No,
January.
No, letter was written on 13/8/25.
That was earlier lawsuit. And this is the latest instruction I have received from the director of lawsuit, where a reminder letter to the Superintendent of Police Sirang district has been issued by the this office by letter number so and so dated 21/2026. However, no report is received from the office of the Superintendent of Police Sirang district lawsuit. This is the
You mean to say after 13/8/25, another letter was written?
Yes. That letter lawsuit.
No, this letter is addressed to you.
No,
Hmm.
And even
21/26.
yesterday lawsuit one letter has been issued. I have received it just now. Okay, that would be good. Thank you.
So what is to be done?
Print out-
May I please lordship?
Print out of which? Just a minute.
No, I received a letter in second, a written, letter written by the director yesterday, Lordship, to the SP. I have just received now, Lordship.
So how many letters you written so far?
On 2025, we have received one, Lordship,
Correct. One letter is in 13/8/25.
and one letter on 2026.
Second letter on 20th of January 2026.
On yesterday, another letter was issued, Lordship, to the SP, and even telephonically, the director has consulted, have a conversation with the SP, that I have been told on. That he has telephonically have a conversation with the SP to requesting him to provide that report immediately, Lordship. Would I then be? That is it. Yeah.
Yes, you wanted to say?
Lordship, may I point one thing, Lordship?
Yes.
Lordship, may peruse page 28, annexure 8, Lordship. This contempt has arisen subsequent to second round of litigation, Lordship. Lordship, may peruse page 28, annexure 8. It was an earlier order, Lordship. Page 28, annexure 8. And relevant portion is at page 33, Lordship. Page 33, Lordship.
Hmm.
On the first line, Lordship, as already noticed above, both the periods prior to 1997 and for the period 9/8/2000, petitioner has been paid salary. Invoking FR 17 in respect of the petitioner may result in break in service for the said period. Though through proviso of FR 17 states that an officer who is absent from duty without any authority shall not be entitled to pay an other allowance for such period of absence. The expression without any authority as appearing in proviso FR 17 may have to be understood in the more particular manner, having regard to the contextual fact of the case. A legal principle has to be interpreted not in a vacuum, but in the facts and circumstances of a case, having regard to its applicability. If it is in the public domain that during the period from 1997 to 2000, during which period petitioner could not attend duty in Amguri High Secondary School situated in Kokrajhar district, the aforesaid area was affected by widespread insurgency and related violence, which prevented the petitioner from attending to his duties. Failure to attend duties in such circumstances may not amount to willful absence from duty without any authority when the rule of the authority itself came under a cloud. In such circumstances, court is of the view that a period from 10/9/97 to 9/8/2000 is required to be regularized to ensure that there is no break in service of the petitioner with potential impact on his pensionary dues. Lordship, this part, Lordship, this honorable court has already dealt with.
That was already regularized. Lordship, kindly.
Taking
see
into,
the
taking
case
into,
back.
taking into consideration that he could not attend the office due to the instances. That part has already been reflected in the High Court's order. May I read
Now, question is regarding payment of area.
that period, for that period, Lordship?
Period
May I read
period has
further?
been regularized.
Regularized, Lordship. Now they are seeking again, this get report from the SP now. May I read the next paragraph? Therefore, the Director of Secondary Education Assam is directed to regularize the service of the petitioner for the period from 10/9/97 to 9/8/2000 with all consequential benefit. Therefore, insofar the specific claim to salary for the said period is concerned, having regard to the discussion made above and in view taken by the court, the absence from duty by the petitioner may not amount to absence without authority. Matter is remanded back to the Director for Secondary Education Assam to pass fresh consequential order in the light of the above discussion. So what I'm submitting before Lordship, that period has already been dealt with by this honorable court in earlier litigation, and in the present order also, this honorable court has directed that the order passed earlier will hold the field, Lordship. The last line of the present order, Lordship, present judgment. Now, again, Lordship, the government is taking the same exercise after 16, 17 years, Lordship. Now the petitioner is more than 70 years old, Lordship. If your Lordship peruses page 45, para 9, Lordship, the second part of the order, Lordship.
45.
Page 45, Lordship.
What is 45 order?
On which I have alleged contempt, Lordship. My landed friend has read para 8, And
I have also read para 9 also.
last
one-
line, Lordship.
The one which you just read
Yes,
is
yes.
earlier writ petition.
Yes, sir.
Lordship.
How many- How many writ petitions did you file?
This is the second, this was the second, Lordship. Upon which-
Why did you file two writ petitions?
No payment, Lordship, no payment was made, Lordship. I have retired, Lordship.
No, 5469 of 2014,
Lordship. Lordship, that order I read, just read, Lordship.
just read.
And that
that-
period has been regularized. with-
That was for regularization
Yes,
and,
That was regularized for pensionary benefit. That was already done, Lordship.
and the second writ petition?
Second, Lordship, paragraph 9, Lordship.
No, tell me, what is the second writ petition about?
Non-payment of the salary, Lordship.
Area salary.
Area
Salary. Okay, you want to read which part?
Only para 9, Lordship.
Yes.
If the authorities come to the conclusion that the petitioner was indeed prevented from attending school for the aforesaid period because of the threat perception on account of the various extremist activities taking place during the aforesaid period as claimed by him, the petitioner would be entitled to salary for the said period in question, since petitioner cannot be made to suffer for results beyond his control. In that event, the authority will grant all consequential benefit to the petitioner as had been directed by this court by the order dated such and such, passed in WPC number 5469.
Okay, so it says if the authority come to a conclusion, director has come to a conclusion saying that after all, he may be entitled.
Lordship.
Now, what they say is the government says have a relook at that in view of the report submitted to be submitted by the SP.
Lordship.
So that aspect has been looked into.
I'll be only paying, Lordship, little bit hurry, Lordship, because he has already attended order 2016, Lordship.
Please write down. The petitioner had filed WPC number 5469 of 2014. Claiming regularization of his service for the period between 1997 to 2000 and for release of salary and consequential benefit. Subordinate petition was disposed of by order dated 31/8/2016 with a direction to regularize the break period. Stop as far as insofar as claim for area salary was concerned, the respondent authority was directed to take a fresh decision in the matter. Stop, since such decision did not culminate no, since such decision was not taken, the petitioner filed WPC 7467 of 2017, which was disposed of by order dated 4/3/2020. By directing the petitioner to submit a detailed representation with supporting documents before the responding authority concerned, with a further direction to the responding authority to consider and dispose of the representation by passing a speaking order. On the claim made by the petitioner for his area salary. Stop. According to the petitioner, as no steps was taken, the petitioner has filed the instant contempt petition. Next para, Mr. SNT Chisti, Learned Counsel for the respondent. Submits that the Director of Secondary Education has already taken a decision on what was the date, 23?
Yes, Lord, 23,
When did you take the decision?
16/10/2023.
On 16/10/2023. To the effect that the petitioner may be granted the arrears salary for the gap period with effect from 10/9/1997 to 9/8/2000. However, the Director has been asked to re-examine the matter in the light of the police report to be submitted by the Superintendent of Police, Chirag. In terms of the investigation, initiated by the officer in charge, Bijli Police Station, on 11/9/1997. Most of the Learned Counsel submits that although two letters had been written to the Superintendent of Police on thirteen 8/2025 and thereafter on 21/2026. Comma, as there is no response,
And lastly, on 23/2.
the Director has once again written to the Superintendent of Police on 23/2/2026. To furnish the up-to-date status or the outcome of the investigation. So Mr. SNT Chisti, Learned Counsel, submits that since the report of the Superintendent of Police is awaited, he may be granted further 2 weeks' time to obtain up-to-date status. Considering the same, matter stands adjourned to be listed again on Swans. Given. What date? 11 March.
Obliged.
22.
May I please, your lordship, I have to take step on respondent number 4, fresh step. So 10 days time may be allowed to take steps on respondent number 4.
Service not completed.
What is the matter?
Grade 4 employee, he was, your lordship, on dated 10/4/1994 by the managing committee of Mohurur Char High School, and accordingly he joined the respective same school, your lordship. Thereafter, your lordship, the petitioner could not be regulars and he was remained dropped. And your lordship, though his service was approved provincially, signature of your lordship, inspector of DDC, has not been given, your lordship. And as per to the said date, your lordship, on dated 28 February 2018, the governor of Assam pleased to amalgamated the earlier school, Mohurchur Char High School, with Mohurur Char ME School under the Siksha Khetra scheme, and that school was amalgamated. And recently, your lordship, the campus was pursuance of 2016 and 2017, dated 22/9/2016, and accordingly the said Mohurur Char High School is amalgamated with Mohurur Char ME School.
We file affidavit.
No, your lordship, I'd like to file our affidavit. So kindly, your lordship, grant us 2-week time, your lordship, to file affidavit.
As paid for by the learned counsel for the petitioner. Further 10 days time is granted for taking steps. No, what 10 days time? Further, further 3 days time is granted to take steps for service of notice upon respondent number 4. What further? Outside? Time is granted to take fresh steps. To take fresh steps for service of notice upon respondent number 4 by speed post. Ms. P. Das, learned standing counsel, secondary education,
1, 2, and 3, respondent numbers.
appearing for respondent numbers 1, 2, and 3, praised for and is granted 2 weeks time to file counter affidavit. List again after 2 weeks.
I'm deeply obliged.
23 and 24.
Noam Judis Khatna, he is on lady Potma 1. He will NJ
Who?
Khatna near lordship.
Continue.
Yes, please. Just for finding lordship.
Review.
The review has been filed by him, lordship. He will.
All right. Time being.
25.
25 lawsuits, I have checked lawsuit that Wakalama we have received lawsuits, but we have misplaced it somehow, though we couldn't file. Lawsuit my 1 week time lawsuit me to get the instruction and also to file Wakalama lawsuit.
Judgment date
Yes, I have gone to it. lawsuit. I
29
have-
4.
It was sent to us lawsuit, but we have somehow misplaced. It is our fault lawsuit. So we couldn't file the Wakalama lawsuit.
You'll file Vakaranama, then apart from that, what else will you file?
Lordships, in fact, we are supposed to file affidavit also, lordship. Then 2 weeks they may.
Filing a Vakaranama is not sufficient.
Yes, Lord.
You have to file your show cause reply also.
Yes, yes.
Mr. SMC Chisti Learned Counsel submits that he has instructions to appear on behalf of the respondent and prays for a week's time to file the power. He also prays for 2 weeks' time to file show cause reply. Prayers allowed.
Apply.
I am praying for fixing a date, Lord.
List again on so and so.
14th March.
Hmm.
1-3. Oblige.
Yeah, His Lordship, this is the petitioner has approached third time because after expanse of his remarks and the observation that there is no such materials for which he was down from this, lowered from this original post of HOD. So he appeared this honorable court by 86, page 86. Direct.
Last time you submitted that you want to examine whether you're covered by the division bench judgment.
Yes, I have examined.
Are
I
you
have
covered?
examined, yes. My case is in different footings only because here I have found, my lord, there is a case, one person's, he was continuing with the HOD for more than 3 years. Then some others was given by on rotation, he challenged this. Honorable single judge has dismissed, and honorable division bench also hold the same view that since there is a notification, 3 years is the tenure. After the 3 years, some other will get the opportunity. That is the findings. In my case, my lord, before completing 3 years, bringing some false allegation and stigma, I was down. Then it is interfered with. Then I am expected at least to revive me, reinstate me, then allowed to complete the tenure or at least revive me because under Article 21, my reputation is lowered without any reason. That is why last procedure, the honorable court has directed to you approach by find the representation. It will be dispersed by speaking order. And a speaking order speaks about this notification that 3 years is the tenure. When 3 years completed, your time will come, will consider. Now 3 years not completed. Secondly, my lord, the incumbents was given the 3 years also completed now. So that is why at this juncture I have applied that it is all about this reputation. So this is the order. Issue is that there in this case, issue is that he is continue 10 years, then some junior is given, he approached this court says, no, 3 years, you have completed 3 years. That is a notification 5/7/2012. Here says that it should be notification. If any competent person is available, then this notification come in the way, he will continue his competent persons is there, they should also experience headship. That is the findings. But in my case, it is not like that. My humble submission is that it's covered by my case.
Regarding service of notice, what is the position?
My lord, notice all is competent. Appeared. Oh, no, madam. I have taken steps to all. Now, official respondents as well as respondent
I am
5,
appealing for respondent 5.
but principal is
5.
appeared. Others, my lord, GB or others,
6 and 4.
they are not. I have taken all, but they have not. But but my lord, page 86, only specific direction is given to principal, the final speaking order, and he will.
We are
dispose it.
concerned with notice at this stage, okay?
Yes,
Now 5 he is appearing. What about 4 and 6?
4 and 6 not appeared, but I think there is.
Who are they, 4 and 6? 4 is governing body.
GB.
6 is the private respondent.
GB is not existed or not, I don't know, but in GB, in the address to GB, we have sent registered post today.
Anything written in the correspondence? Office note is not very clear. It's just notice has been received by, that's overwriting is there. Number 4. Respondent number 4 is the governing body represented by the President, Dr. Indira Kumar.
Five,
Five is appearing.
then six.
Six is what? Delivered.
I think deleted. Here also deleted. Respondent five. 7126. Which one?
5 and 6 delivered. And so what is to be done with respondent number governing body?
GB, my
Number
lord,
4.
4. Now,
Yes.
whether GB is in now new GB or old GB, I have no idea, but we may try by Dusty also. If your lordship feel that it's a necessary party to this, we have make also party. So
It has come back. The postal note addressee left
yeah, that is why, my lord, GB is not, I think,
RTS,
Yes.
return to sender.
because my lord, after some 10 years, GB also changed sometimes. So yeah, that is why they have not accepted receipt it, although it was reached the destiny. So at this stage, my lord.
What is to be done?
My lord, we may try my luck by Dosti also if there somebody has on behalf of GB receive, or otherwise, I don't know, my lord. They are going to receive because GB is, I don't think now it's GB is new GB form one. Or my lord, somebody is directed is on behalf of GB. He is not there, Indra Kumar Bhattacharya. The Gauhati College. President. Now president has changed, my lord. New president, we have not collected the name. That is why he refused. He left this GB.
Please write down on perusal of the office note dated 27/1/2026 and 21/2/2026. Our notice is accepted to be complete on respond numbers 5 and 6. Stop today, Mr.
RK Mohanto.
R.K. Mohanto. Learned counsel appears for respondent number 5.
Five.
Are you going to file any affidavit
Yes, Lordship.
and place for how much time?
4 weeks.
4 weeks time to file counter affidavit. Stop insofar as respondent number 4 is concerned. Notice that was sent has returned back with a postal note, open inverted comma, addressee left, RTS, close inverted comma. Stop. Mr. PJ, no, Mr. MJ Barua, learned counsel for the petitioner submits that he may be permitted to take steps.
My lord, it may be a in general mode of means that can also be served if I goes from court through court civil.
How?
My lord, if your lordship directed.
No, if the addressee left, then how
That
they
is the
start?
problem, my lord. That will be same wrapping. We may dusty mode, then we can make inquiry and by then, but that.
Mr. MJ Barua, learned counsel for the petitioner submits that he may be permitted to serve notice by way of Dasti. Prayers allowed. Petitioner shall serve notice to respond number 4 by Dasti within 10 days through the registry of this court and thereafter file an affidavit to show proof of service. Remaining respondents are the remaining respondents to file their counter affidavit. List again on so and so. Yes.
Hello?
Yes.
The office note indicates the postal receipts that service is completed, my lord, on respondent number 5. The private respondent, my lord.
5.
Respondent number 5.
This right, although the ID card nor unserved, no, right like this, although AD card or unserved notice has not been received back from the respondent number 5. But office note dated 21/2/2026 indicates that on tracking the postal consignment, it has been found that the item has been delivered to the addressee on 2/2/2026. Now, taking into account the fact that the item was delivered to the addressee, notice is accepted to be complete on respondent number 5. Who is appearing for the others?
On the earlier occasion, my lord, my friend, Ms. N. Sharma appeared for the education department, my lord.
Next para, in view of above, list this matter. When?
My lord, one small submission I want to make, my lord. In item number 28 also, the tagged matter, my lord, 28. The private respondent's services was affected, but she chose not to enter appearance. Even in item number 27, my lord, I understand that the same thing has probably happened. So, my lord, the matter is ripe for admission hearing, my lord. Because the grounds have already been stated by the state, my lord.
These two writ petitions are by the same petitioner.
Same petitioner, my lord. A subsequent cause of action that arisen, my lord, due to which item number 27 was filed, my lord, subsequently.
In view of above, list the matter in the admission column after 3 weeks. Give a date on so and so.
7th April. 7th April. Fifth,
Then the other case, you write
my lord.
item number
28, my lord.
28. Office note dated 2/9/2025 indicates that although AD card or unserved notice has no return back from respondent number 5, but the postal track consignment shows that the item has been delivered to the addressee on 30/7/2025. Accordingly, notice is accepted to be complete on respondent number 5. List the matter in the admission column on so and so. Same date, huh? Same date.
37 of the supplementary list.
Yes, who is appearing for the respondents?
For department.
Hmm. Where is the affidavit? Department means respond number 5 to 8. Is it 5 to 8? Governing body, Dibrugarh. No, 5 to 8 is the college. Department means higher education. Respondent numbers 1 to 4. None appears for the petitioner when the matter is called. The, huh? You should be more worried about your affidavit. You have not filed an affidavit. Reconstruct your file. The respondents also have not filed their counter affidavit.
Fine.
Your good name?
Yes, Gautam, your lordship.
Mr. S. Gautam, learned counsel, appears for respondent 5 to 8, while Mr. S. Bhuya, learned standing counsel, education appears for respondent numbers 1 to 4. Are you going to file or not?
Yes, your lordship, but lordship, I will require 2 weeks time. Your lordship.
That's paid for. 2 weeks time is granted to them to file counter affidavit. List again on such.
Permission item 5.
In this case, man, I have been served with an affidavit at 10:30, man, today.
Rejoinder.
Time, man.
I'm sorry, counter affidavit.
My lord, after a period of 6 years, man.
Hmm.
But
So?
nonetheless, man, I would like to go through it.
Okay.
And I also pray for an early date, my lord. These people are serving since 1990s, my lord, without ceremony, as music teacher,
You have it today then.
my lord.
You can have it now itself if you want to.
No, my lord, the affidavit they have filed, my lord, today at 10:30, I have got, my lord. I'd just like to go through it. And if necessary, I'll file a reply, short reply. Otherwise, my case is also covered by Supreme Court.
Mr. B.D. Goswami, learned counsel for the petitioner, submits that he has just received a copy of the counter affidavit filed by the
By the, my lord, respondents.
secondary,
All 1, 2, and
by
3.
the respondents,
1, 2, and 3.
and submits that he may be given some time to go through the same and file a rejoinder affidavit if so required. To stop. In view of above,
May I pray for 6th?
give a date, which is the convenient,
16.
16,
March.
16 March.
March of that.
List again on 16th of March.
Fine.
List on 16th of March. Petitioner will be at liberty to file rejoinder affidavit,
Fine.
so advised.
Item 6.
May I please your lordship? In this case, petitioner claiming her service pension, my lord, as well as arrear pension with effect from the date of her retirement.
What do you mean by service pension? Arrear pension, I understand, but what is service pension? Is there any such kind of term as service pension? Family pension is there?
Because she was retired in 2019, 31/7. during
Retired
this
as what?
Her service was not regularized. Till date, she has not received her pension, my lord.
She
Service
retired as what? Assistant teacher.
My lord,
She retired from which post?
my lord, assistant teacher.
Then-
Her appointment is page number, kindly peruse page number 27, my lord. Her appointment was ad hoc, but in a regularly sanctioned post, my lord. Page number 52.
Page 27 is the first appointment order.
Sir, 27. Type copy is in 27, page
This-
number 27. my
This is the first appointment order.
appointment order. Then page number 34 is, my lord,
Hmm.
kindly peruse page number 34.
Yes.
Her ad hoc appointment extended until further order, my lord.
Then
Then my lord may kindly peruse page number 52. Before her retirement, my lord, inspector of school sent a letter to director of elementary education for her ex post facto approval, my lord. So government asks for
Page number
whether the 52, my lord,
52.
post was sanctioned or not. And page number 52, the inspector has mentioned the post was sanctioned post, my lord.
Hmm.
Then, my lord, may kindly peruse the impugn order, my lord.
Hmm.
Page number 53. They have stated that, my lord.
Page
that
number
ad hoc- Page
Fif-
number 53.
53. Yes.
The ad hoc period of her service not be counted towards pensionary benefit, my lord. This is the impugn order, my lord.
Your entire period is on ad hoc basis,
My lord, may kindly now peruse page number
isn't it?
56, my lord.
See, the entire period of your service is on ad hoc basis.
Ad hoc basis, time to time, they have transferred me in different government school, my lord.
But you remain to be on ad hoc basis, Sandy. Na?
My lord, I am kindly peruse 56, my lord.
56, yes.
My lord, from right, Dipen Borua. His appointment also ad hoc basis.
Hmm.
Similar situated, but my name was in the list of third number, my lord, Lilima Begum. Dipen Borua, then Madhav Upadhyay, then Lilima Begum, my lord.
Yes.
We are similar situated person, my lord. Now, my lord, may kindly peruse page number 55. This is Dipen Borua's. The service of Dipen Borua was appointed on ad hoc basis, my lord. His appointment also ad hoc basis, but now he regularly getting his pension, my lord.
Okay.
In their affidavit, my lord, they have taken same stand, my lord, that ad hoc period is not count for pensionary benefit. My lord, may kindly peruse my affidavit in reply. I have endorsed 2 OM, my lord.
Yes. Which OM?
My lord, may kindly peruse my affidavit in
Reply.
reply, my lord.
Page number?
Page number 59 is my stand, my lord. And OM is in page number 64 and 66, my lord.
No, this has been repaginated. It's not tallying with yours. Please refer to the paragraph number.
My lord,
Please tell me the paragraph number.
paragraph number, my lord. Paragraph number 6, my lord.
6.
1, Roman 1 and Roman 2.
This is page 65 in my copy. In your copy, I think it's page 59.
My lord, page 59.
My copy is 65. It's repaginated.
6 is my stand, my lord.
Please read.
I have enclosed that as regard to the statement made in paragraph 6 of the affidavit in opposition, the deponent respectfully state that non-finalized of service pension on the ground of ad hoc period of service of the petitioner will not be counted for the pensionary benefit. It's illogical, irrational, and against the mandate of the Honorable Supreme Court. The Office of the Director of Elementary Education, Assam, by order dated 22/6/1993 extended the ad hoc appointment of the deponent until further and till date. The deponent continuously discharging her service without any break till her retirement with a regular payoff scale against the vacant post of earlier incumbent. Annexure 4 of the writ petition, my lord. After discharging more than 28 years of service, the ad hoc appointment of the deponent was not regularized by the state respondent, although service of other similar situated incumbent have been regularized from the Same list, the deponent is eligible for getting her pension on the following ground, my lord. I have enforced the OM, my lord.
Hmm.
And my lord,
Let us see the OM. Annexure A.
my lord, annexure A and I have enforced. And my lord, in paragraph number 6 of
Let us-
paragraph 6, Roman
Let
6,
us,
my lord,
let us see the annexure first.
my lord.
OM. Annexure A.
A, my lord.
Which one is relevant?
My lord, both 20 years under the government without being confirmed.
Read from the beginning, the government of Assam.
Some circular issued under the memorandum who retire after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefit as available to the retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. The said OM come into force with effect from 1st September 1982, my lord.
Hmm. How many years you have rendered service?
My 28 years I have,
28 years. Then the second paragraph.
my lord.
Read the second paragraph of the OM.
The governor of Assam is now pleased to clarify that all temporary government employees who have retired from the service under the governor of Assam, fulfilling the criteria of not less than 20 years of continuous service, will be eligible for pension from 1st September 1982 onwards. This is, however, subject to the condition that they satisfy all conditions other than be conditions of permanently against permanent post under the Government of Assam for usual pensionary benefit under the Assam Service Pension Rule 1969. This benefit not be admissible to any retired who retire from service with retirement benefit under CPF rules.
This is a type copy. Annexure A is a type copy. Where is the original? Do you have a type copy of this OM? I mean, sorry,
Right.
original copy.
I don't have right now, my lord. I can produce. I can submit, my lord.
The second paragraph, second line. Is this a mistake or this is what actually it is?
My lord, the governor of Assam is now pleaded to clarify that all temporary government employee who have retired from the service under the governor of Assam.
Under the governor of Assam
Yes, my lord.
or government?
Under the governor of Assam. Maybe.
There seems to be some discrepancy.
This is type copy, my lord.
That's why I'm asking you the original.
My lord, I will submit.
Perhaps it should be government of Assam, not governor of Assam.
My lord, maybe. Government of Assam. It's typographical mistake.
So your case is that as per the office memorandum, you are entitled to pension.
Pension. Because I
In
have
fact,
completed,
you have taken the example of one person,
my lord, person.
Dipen Barua.
My lord, and in page number, in my affidavit, my lord, page number, paragraph number 6, Roman 6, my lord. And Dilip Gayan also is getting his pension. His appointment was also ad hoc, my lord.
Dilip Goyan.
Dilip Gayan, my lord. He is also similar situated person.
Where is his name?
My lord.
Where is his name?
My lord,
Any document?
my lord, in page number 56 in my petition, my lord.
56.
My lord. From right, Fifth name is Dilip Gayan, my lord.
Oh, this Dilip Gayan.
My lord.
The other one was Dilip Borwa
Dilip Gayan and Dipen Borwa.
or Dipen Borwa.
Yes.
Both of them have got the benefit of
Getting
pension.
pensionary benefit.
They also were working on ad hoc basis.
Top basis.
AT means ad hoc teacher. AT.
Assistant teacher, my lord.
Oh, assistant teacher.
All are assistant teacher. Now
So-
67 years old, my lord.
So how do you say that this Dipen Borwa and Dilip Gayan, they were ad hoc teacher?
My lord, in his order, my lord, in page number 55. Page number 55, my lord.
Hmm. Was appointed on ad hoc basis.
Right.
So what do they say in their counter affidavit?
My lord.
What do they say in their counter affidavit about this
My lord, they have
2%?
their only stand is, my lord, ad hoc period is not counted for pensionary benefit. Same, my lord, in their affidavit. But they had and was same, my lord, impugn order.
No, definitely they say ad hoc period is not counting, this cannot be counted for pensionary benefit.
The pensionary benefit to
But what about these 2%? Dipen Barwa and Dilip Gayan, what do they say? They are different.
no, they are same.
Yours, the next, what is this? Roman 17 and 18. Roman 17, 18. Paragraph number 21 and 22.
As per Rule 31 also, service and pensionary Rule 1969, I am also entitled, my lord.
Ms. Phukan, petitioner has said that similarly situated persons have been given pension. And they have taken the example of these 2 persons. Dipen Borwa and Dilip Gayan. And the statements are made in paragraph number 21 and 22. But in your counter affidavit, you say that there's no comments. What do you mean, no comments?
As per our affidavit already, we have previous. We have.
No, you come to your page 60 of it,
Then ad hoc
page
period
60.
But they have not mentioned the aspect of.
Just a minute. Page 60. Come to page 60. Paragraph 7. Your counter affidavit, paragraph 7. Petitioner says that I am ad hoc employee. I have served 28 years. I should be given pension. Like, and has taken the example of 2 persons, one Dipen Borwa and one Dilip Gayan, who were also ad hoc employees but given pension. Specific amendment made in paragraph 21, 22. And you say no comments. What do you mean? That means you accept.
And I have to talk with the department.
No, why do you want to talk with the department now? You should have cleared the matter when you were drafting and getting it vetted. There has to be a response to that. Either you say these people are different, petitioner is different, they're different, they cannot be covered. Different because of this reason. Or you say that yes, petitioner is also similar. You cannot just say no comments like that.
My lord,
What is your stand? Tell me.
See today, my lord,
Huh?
she has not rendered. My lord, I have received some instruction.
What instruction? What instruction?
Instruction, my lord.
Huh?
Take, my lord, some,
What instruction you have received?
my lord, I have not the soft copy. As per the verbal instruction I have received, my lord, she has not rendered 20 years. My lord. So, my lord, sometime you'll be allowed to receive that instruction and to file another additional affidavit.
No, no,
regarding
no.
this
See,
matter.
that instruction should be in your affidavit, which was filed on 20th of May, 2023.
Yes, ma'am. So sometime may be allowed. Kindly to file another.
No, unless you show me what is the instruction, I cannot just give you time like that. Huh?
Just before some time, my lord, I have received some verbal instruction, my lord. That-
So what is that verb?
Rejected her claim, my lord.
Rejected our claim. That is why she is before the court. Court will decide now.
So sometime may be.
At least tell us why you have not given her the pension.
The ad hoc period, my lord.
No, for some people you have given. For some you have not given. Why?
If she has not rendered 20 years, my lord, so how can she come?
He has rendered 28 years, madam. 28 years.
28. And
Office memorandum says 20 years of service is enough. OM says 20 years is good enough for giving pension. Your OM. Petitioner has rendered 28 years.
another, that finance is not a party here, my lord.
My lord,
Maybe.
financial party already, we have implemented.
In the,
We have already implemented, my lord. I have lots
so
of
my lord,
Supreme
sometime
Court
we are
judgment
allowed
also.
to file our additional.
No, no, additional affidavit sometime for what? Where is your additional affidavit? Tell me, what is the instruction?
And that will be taken tomorrow, my lord.
No,
Provide.
if you wanted to take time for additional affidavit, you should have informed the court
For
at the
the
first
instruction.
instance.
For the instruction.
No, see, before she starts opening, you should say that I have received additional instruction, give me some time. I will file affidavit. You did not say that. Only after I asked you what is this, then you started saying I have some additional instruction. What is this, Mr. Fugan? Miss Fugan?
I was retired in 2019, my lord. Now I'm 67 years. I have filed this writ petition in 22, my lord. Now 26. I'm suffering.
You tell me what instructions you have received. So that I can give you time meaningfully. Otherwise, just like that, giving time, what? Why should I give you time like that? Why should we take it up tomorrow? Give me a reason why.
Because I have not the copy of the instruction, my lord.
Then how do you know that you have the instruction?
As per verbal instruction. which I
Verbal
have received, my
instruction.
lord. Yes, my
What
lord.
is the verbal instruction? Tell me.
She has not rendered 20 years, my lord.
Verbal instruction.
They
Yes,
have
my
not
lord.
mentioned in our dear
How do you intend to file your verbal instruction, madam?
So that I have to receive that instruction, my lord.
How will you file your verbal instruction? Tell me. You should take things more seriously. People are coming here to file cases, spending all their money. If they have a case, they will get the relief. If they don't have a case, they'll not get the relief. You have to be very precise and take things seriously. If she's not entitled to give me the reason that these are the reasons she's not entitled to, then we'll dismiss the writ petition. But if you're not able to show that, then court will have to decide. And importantly, two names have been pointed out. I told you again, I'll tell you again. You have not bothered to reply to that also. You just say no comments. Please write down. The case of the petitioner is that she has rendered 28 years of service on ad hoc basis as assistant teacher, and that she should be given pension. Stop, the petitioner has taken this example of one Dipen Borua and Dilip Gayan, who were also assistant teachers and serving on ad hoc basis. Stop, the petitioner contends that the services of these two teachers, importantly, services of Dipen Barua, have been regularized by giving ex post facto approval by order dated 2018, bracket annexure Roman 17, passed by the Director of Elementary Education. Stop, specific statements have been made in paragraph number 21 and 22 of the writ petition. But surprisingly, the Department of Elementary Education has no comments to offer against paragraph number 21 and 22 of the writ petitions, which can be seen from paragraph number 7 of the counter affidavit. So, Ms. N. Fugan, Learned Standing Counsel, Elementary Education, submits that she has received additional verbal instructions, which is to the effect that the petitioner has not served for 20 years. To claim pensionary benefit. Stop, such a stand is not available in the counter affidavit. And further, such verbal instruction, and further, the acceptability of the verbal instruction. No, you read them, and further, such an instruction being only verbal, the same cannot be accepted without any supporting documents. Stop, however, as the Learned Standing Counsel praised for some time, the respondents are given 10 days time to file an additional affidavit to clarify the specific amendments made in paragraph number 21 and 22 in the writ petition. Stop, if such affidavit is not filed, the matter will be considered on the basis of materials available on record. List again on so and so.
Deeply obliged, my lord.
Item 9.
Made with your lordship.
Yes,
So this is a covered matter, lordship.
covered matter.
Lordship.
Here, as per our affidavit, petitioners are excess teachers and excess teachers. And as per Purnima, our judgment, my lord, they are not entitled for the all kinds of.
It is not a covered matter.
No.
So dispute is there.
Dispute is there, lordship, but in my writ petition, lordship.
It is not a covered matter according to him. According to you, it's a covered matter.
Lordship, and they have not denied in their affidavit, lordship.
But now you tell me what is the claim first.
Lordship, what happened, Lordship, they are teachers under the elementary education department, Lordship.
Yes.
So they were appointed in the year 93-94, Lordship.
Hmm.
And thereafter their services were reaffirmed in the year 2005, Lordship.
Reaffirmed means? What do you mean by reaffirmed?
What happened, Lordship? A one-woman committee was from Lordship regarding their services, Lordship, and under teachers under the government of Assam, Lordship.
What is your claim?
Lordship, to place the petitioners under the old pension scheme, Lordship. That is my claim,
1969.
Lordship. And regarding this, similarly situated persons have already approached this honorable court, Lordship. And by order dated, Lordship, 12/8/2021,
Hmm.
their services were categorized under the old pension scheme, Lordship. Same district, Lordship, Nagaon district, Lordship.
How did that happen?
Lordship, kindly peruse the appointment orders, Lordship, at page 20 annexure A, Lordship.
No, you say that some others have been given that benefit.
Lordship,
How it was given?
Lordship, kindly peruse page 40, Lordship.
By order of this court?
Lordship. Page 40, Lordship.
14.
40, Lordship. It starts from page 40, Lordship.
How many of them?
Lordship, another group of 170 teachers, Lordship.
This covers two judgment. I mean, it's a common order
Lordship,
in two writ petitions
Lordship.
pertaining to which district?
Lordship, Nagaon district. We are also from Nagaon district, Lordship. We are appointed.
You were appointed in from the year 1993
Lordship.
as what?
Assistant teacher, Lordship.
Assistant teacher in LP school.
Lordship. ME school, Lordship.
ME school.
Lordship.
Petitioners have retired or they're still working?
One retired, Lordship. Others are working, Lordship.
One retired.
Lordship.
How many petitioners are there?
Lordship, there are 5 petitioners, Lordship. Petitioner number 2 retired, Lordship.
She retired during the pendency.
Lordship.
Okay.
Maitri Banik, Lordship. She retired, Lordship.
Okay, read page 40.
Lordship, page 14, Lordship. Lordship, page 14, Lordship.
Paragraph 4 onwards.
Lordship. Can I go through it, Lordship?
Yes, read.
WPC 7837 of 2015 has been instituted by 39 numbers of assistant teachers working in various schools in the district of Nagaon. It is claim of the petitioners that they were initially appointed on honorary basis pursuant to a decision of the government to regularize their services. Their services were regularized from the year 1993 onwards. Subsequently, Lordship, a one-man committee was constituted by the government to inquire into the appointments of the petitioners and similarly situated persons, which culminated in a report published in the year 2001. The appointments of the petitioners were found to be in accordance with law, and in the year 2005, the Director of Elementary Education issued an order of reaffirmation, Lordship, of the regularization of their services. The orders of the director had divided the group of teachers into two groups, one group consisting of 277 teachers appointed against excess post, Lordship, and another group of 170 teachers appointed against the vacant post, Lordship. We fall in this category, Lordship. The petitioners claim that they belong to the group of 170 numbers of teachers who were appointed against the vacant post in the district of Nagaon. However, as a precondition for regularization, the petitioners were directed to give an undertaking that they would be covered by the new pension scheme, which had come into force in the year 2005, and they would not fall under the pension rules under which they were regularized. The petitioners been aggrieved by such action are before this honorable court. The petitioners in WPC number 8694 of 2018 are the assistant teachers in different schools in the district of Kamrup and are similarly situated as the petitioners in WPC 7873. It is the claim of the petitioners that subscription under the GPF, GIs, etc. were deducted regularly in accordance with the Assam Services Pension Rules 1969 rules. However, the petitioners were being deprived of the benefits under the 1969 rules, and rather they were sought to be brought under a new pension scheme, NPS. As indicated above, the issue involved has already been decided by this court by a judgment dated 28/4/2015 passed in WPC 3662 of 2009. It has been held that the NPS would not be applicable to the petitioners whose services were regularized prior to the amendment of the 1969 rules. It may mention that the judgment order 28/4/2015 passed in the aforesaid writ petition was the subject matter of review in review petition number 16 of 2019, and this court by an order dated 11/2/2021 has dismissed the prayer for review in the following manner. In the present case, the petitioner service having been regularized on 4/6/2008, the petitioner became regular government servants on 4/6/2008, and as the 1916 rules was in force at the relevant point of time, the executive instruction issued could not have overridden the statutory law. As such, the court had accordingly directed that the petitioners would be governed by the 1969 rules and not by the new defined contribution pension scheme, which came into force only by way of amendment of the 1969 rules in the year 2011. In the case of Dilip Kumar Ghosh versus chairman reported in 2005 7 SCC 567, the apex court has held that circulars, notification, administrative, executive instructions, orders, etc. cannot override statutory rules. It is accordingly submitted at the bar that the aforesaid judgment 28/4/2015 has not been challenged in any forum and has attained finality. In view of the above, this court is of the view that the present two writ petitions can be disposed of in the same line of the order dated 28/5/2015 passed in WPC number 2009 by holding that the petitioners would be governed by the Assam Services Pension Rules 1969 and not by the NPS.
What about your services? When was it regularized? Do you have you made a chart or something like that?
Lordship, it is in the appointment order itself, Lordship.
To make things simpler, you should have made a chart.
Lordship.
Date of appointment, date of regularization.
Page 20, Lordship, Annex A, Lordship.
Page 20.
Lordship.
20A or 20.
20, Lordship, Annex A, is hereby regularized to the sanctioned post, Lordship.
With effect from. Spelling also wrong. Effect spelling is EFFECT.
Lordship, Barnett.
You have typed AFFECT.
Lordship.
Huh?
Annex A, Lordship.
New pension rules came into force on which date?
Lordship, 1 to 2005,
1, 2,
2005, Lordship.
whereas you have been regularized in the year 1993,
Lordship,
prior to the new pension rules coming into
Lordship.
force. So according to you, you should be governed by the new, old pension rules.
Lordship.
Then where's the undertaking to be signed by you? Anything like that?
Lordship, undertaking is there, Lordship.
At what stage did you sign the undertaking?
Lordship, after that report, Lordship,
One-man commission report.
Lordship,
Where is that?
Annexure B, Lordship,
Page?
page 24, Lordship. That is the order, Lordship, after that report. Page 24, Lordship. With effect from the date of their joining, Lordship.
What is the date of this order?
Lordship. 17/8/2015, Lordship.
No, 2005, not 2015,
17/8/2005.
2005.
17/8/2005, Lordship. So here it has been
So-
categorically stated, Lordship.
New pension has come into force from 1/2/2005.
Lordship,
That is why you have been asked to give this undertaking.
undertaking, Lordship.
Now, what was the requirement of this one-man commission? Why this one-man commission was,
Lordship, there were some irregularities regarding the appointment under the elementary department, Lordship. Therefore, this one-man committee was constituted.
where is the report?
Report is not annexed, Lordship.
Then,
After the report, this came.
how do we know that a report is made in your favor?
Go to the opinion. Because after the report, Lordship, here it is categorically stated that are hereby regularized with effect from the date of their joining against the vacant post, Lordship. Only because of that undertaking, Lordship, we are not paid the. We were into the new pension scheme only because of this undertaking, Lordship. And regarding the matter is covered under the following judgment, Lordship, they have not denied in their affidavit, Lordship. Paragraph 14 and 15, Lordship.
Undertaking you have given in 2005. Isn't it?
Lordship.
Why do you come to the court in 2023? What is your reply to that?
First writ petition was filed in 2009, Lordship.
First writ petition
Lordship.
means this is
The
the,
basis of
this is
that-
not the first time.
Lordship.
This is not the first time.
No. The first similarly situated persons who
Ah.
had approached this honorable court in the year 2009, Lordship.
Okay.
Thereafter, this writ petition was filed, Lordship. That was disposed of. Thereafter, these petitioners came before your Lordship.
So you are fence sitters.
Lordship.
You have been, your service has been affirmed after the one-man commission submitted the report,
Lordship.
and you have been regularized by order dated 2005.
Lordship.
But you have come to this court only in 2023.
No, we were regularized at the time of our initial appointment, Lordship. But since we were regularized at the time for initial appointment, Lordship. But this one-man committee came, Lordship. Thereafter, they have reaffirmed our regularization, Lordship.
Okay, that happened in 2005.
Lordship,
And it also says that you'll be covered by the new pension scheme.
Lordship.
So why do you come now after so many years?
Lordship, they were under the impression that probably the government will do the needful, Lordship. Probably, Lordship.
That is a very weak point of argument.
Lordship.
They were hopeful that something will happen.
Lordship. And now in the verge of retirement, Lordship, they have approached the Honorable Court. All are 56, 57 years of age, Lordship. One had already retired, Lordship.
What is the status of your pension contribution?
Status, Lordship, that I have to.
New pension scheme is new contributory pension scheme, isn't
Lordship.
it? You have to contribute, government will give the matching.
Lordship.
So
Deductions are made from the salary.
deductions are made. So this happened since 2005. And now you're before this court in 2023. Saying that I prefer to have the old pension scheme, not the new pension scheme. Is it not, are you not barred by delay in latches?
Lordship, but similarly situated persons had already been given relief by this Honorable Court.
They were given relief.
On the same.
On that basis, you're coming.
Lordship,
So that makes you fence sitters.
no,
You were sitting on the fence, waiting to see what has happened to this case. If it goes in their favor, I also will jump in. If they lose, then I don't have any case. If they win, I also will go and pray for same relief. That is called fence sitters. So are you not fence sitter?
Lordship, this is filed in the year 2023, Lordship. 23, Lordship.
But your deduction happened since 2005.
Lordship. But since they are now on the verge of retirement, Lordship, probably therefore they have approached you.
So why have you come at the verge of retirement, at the fag end of your service? Any explanation anywhere?
That part, Lordship. Lordship, paragraph 8 is there, Lordship.
What does
Paragraph
it say?
8, Lordship.
What does it say?
The petitioners move before the respondent authorities for redressal of their grievances, but their respondent authorities have not considered a pair for placing them under the Assam Pension Rules 1962. And thereafter, paragraph 9 is the year on which they were met, year on which their services were regularized. In paragraph 9, Lordship.
Do you have a copy of this WPC 3662 of 2009?
Order, Lordship.
Yes, copy of the order.
Order, Lordship.
3662 of 2009. Judgment dated 28/4/2015.
The 2009 order, Lordship. Wait.
2009 order, what do you mean?
Lordship.
Is there any order in 2009?
First order, Lordship.
In 2009?
Lordship. On the basis of which this second order was passed, Lordship. I will copy.
What is the date of the order?
Sir, Lordship, your date is, Lordship, 28/4/2015, I think, Lordship.
You have to be sure. You can't say, I think. From where are you saying that?
362 of 2009.
There is
Lordship, page 41, Lordship. Page 41. of the writ petition, Lordship.
The case number is not legible.
3662 of 2009, Lordship.
It is not legible. You have given me a copy.
Lordship.
Case number is not legible.
The upper portion, Lordship, probably it is. Yeah. 3662 of 2009, Lordship.
Upper, lower side, all the portion is not legible. Case number is not there. Hmm. What is the relevant paragraph? You trace this judgment also. Find out. Judgment and order dated 1/9/2003. What is this?
19/2003.
Yes. There's a mention in this paragraph 16, paragraph number 19 also. What is it about? 1/9/2003.
That I have to, Lordship.
You better find out. Civil rule number 1571 of 1998, I think.
Lordship. 1571, Lordship.
1571 of 1998.
Nine,
This is clearly mentioned in paragraph number 14.
Lordship.
So
Then I will.
hmm,
Civil rule 1571 1980.
you have a copy of the order?
No, that I don't have, Lordship.
Find out. When do we take up this matter? When can you produce?
On third,
Huh?
Thursday, Lordship.
Thursday? I don't know. Ninth. 9 March.
Lordship.
Otherwise, my lord, both the finance whom I am representing as well as education have filed their respective activities. Once he completes, my lord,
He says it's a covered case.
we will distinguish, my lord.
Can it be on 11, Lordship? 11 March.
Wednesday.
Then 12, Lordship. 12.
Hmm.
13,
9 or
Lordship. 13,
13.
Lordship.
As paid for by the learned counsel for the petitioner. List the matter on 13th of this March 2026. Learned counsel shall produce copy of the judgment and order dated 1/9/2003. Passed in civil rule number 1571 of 1998 for perusal of the court on the next date.
Oblige, your Lordship.
May I please, your lordship? My lord,
Yes.
I am sorry to mention, my lord, one matter, my lord, item number 15, my lord.
Yes.
I don't know, any other date, my lord, may be given, my lord. I have to go out, my lord, because of my medical emergency, my lord.
Mr. Laskar.
My lord.
As placed for by Mr. F.L. Laskar, learned counsel for the petitioner. Let us stands adjourned. To be listed again on I think so.
23 and 24.
Yes.
23 is a review petition filed by the state, my lord.
24 is contempt petition,
Mm.
2017 matter.
We are seeking a review of an order, my lord, passed in the year 2017.
Mm. So there's some delay.
Yes, my lord.
9 years delay.
I have filed an additional affidavit explaining the delay, my lord. In fact, in the review petition also there is an explanation.
Mm. What is the explanation?
My lord.
Yes.
Yes, my lord. It's needed to be-
এতিয়া ফাইল কৰিছিলা এইখন নহয় নেকি মই দেখিছো
In contempt case.
কণ্টেম্বৰ নহয় নহয় ৰ'বা মই চাইছো এইটো
Yes. My lord, page 115, the additional affidavit filed by the review petitioner, my lord.
Yes.
Paragraph 2. May I read, my lord?
Yes.
The present additional affidavit has been filed to explain the delay in filing the review petition. In this regard, it is stated that although the original order was passed on 7/2/2017 in WPC number so and so by holding that the petitioner was also entitled to her salary from August 2007, as the petitioner is similarly situated in persons like in return so and so. However, in the meantime, the issue of illegal and irregular teachers appointed during the year 89 to 91 was dealt with by this honorable court in several proceedings and direct the government in the education department to resolve the issue by taking a concrete decision in respect of all those illegal irregular teachers. By virtue of the order of the honorable court, a screening committee was constituted to resolve the issue of illegal irregular teachers who were appointed during the year 91-2001. The government in the education department carried out a screening process. The petitioner also participated in the same screening process, and the name of the petitioner has been identified as illegal irregular teacher under Dhemaji district, and subsequently she has been accommodated as tutor pursuant to cabinet decisions. The screening committee finally submitted a report regarding appointment and continuation of service of those illegal irregular teachers. In the report, it was found that the petitioner was appointed against non-existent post and was terminated in the year 1992. On the basis of the report of the screening committee, the cabinet has taken decision to accommodate those illegal irregular teachers with the prospective effect instead of terminating them on humanitarian ground. As per the said cabinet decision, the illegal irregular teachers have been accommodated as teacher tutor as per the qualification with prospective effect, and no such incumbents have been given the benefit of past service in any manner whatsoever. Since the petitioner also similarly situated with those illegal irregular teachers, therefore she is also treated equally with them, and no benefit of past service were given to her. That after receipt of the certificate copy order dated 2/7/2017, passed in so and so, a meeting was held on 24/2/2017 for taking decision in compliance with various orders passed by this honorable court, where the honorable court directed to pay salaries to the petitioners for the days on which they have actually rendered services. Upon perusal of the available record, it is seen that between 2008 to 2014, this matter was clerked with several writ petition and contempt proceeding, and no distinct or specific order was passed in respect of the contempt involving the petitioner. Consequently, the case of the petitioner did not come to the notice of the department during the said period. When the matter was again listed in the year 2024, the matter was re-examined, and it was found that the petitioner participated in a screening process, and her name was found in these two categories of illegal irregular teachers under Dhemaji district. That the review petition humbly states that in between from the year 2018 to 24, the matter was clubbed with several petitions and contempt proceedings, and no distinct or specific order was passed in respect of the contempt involving the petitioner. Consequently, the case of the petitioner did not come to the notice of this department and during the same period. When the matter was again listed in the year 24, the matter was re-examined and it was found that the petitioner participated in a screening process and her name was found in list 2 of Dhemaji district under illegal irregular category. As such, the petitioner was accommodated as tutor under so and so. That the review petitioner humbly begs to state that the petitioner accepted her accommodation as tutor under the Act of 2017. After participating in the screening committee, therefore, the department is not in a position to comply with the direction passed in the judgment dated so and so. This further stated that the right of the to salary, pension, and other service benefits are entirely statutory in nature, and the public service, and therefore these rights, including the right to salary, spring from a valid and legal appointment to the post. Since the very appointment of petitioner is illegal and non-honest in the eyes of law, therefore the petitioner is not entitled for relief as paid for. The review petitioner humbly states that although there is some delay in preparing the present review petition, the delay is neither intentional nor not deliberate. The same has occurred described in the preceding paragraph and due to administrative reasons beyond the control of the so-and-so. Upon coming to know about the order at so-and-so, the matter had to undergo examination at multiple levels within department, including seeking legal opinion, internal notings, and approval from the competent authority before taking a decision to initiate review proceeding. The procedural formalities and interdepartmental communication which are inherent in a government functioning contributed to the delay. The review petitioner therefore prays that the Honorable Court may be pleased to condone the delay in the interest of justice and permit adjudication of the matter on merits. So during that period, from 18 to 2024, all those matters are clubbed together, my lord, and were listed. So there was no particular order because this contempt proceeding also were listed along with that those matters, my lord. So no specific order was passed in this contempt proceeding. When these matters were segregated, my lord, the contempt was listed in the year 2024, and then, my lord, it has come to our knowledge that this contempt is pending, and then since the prisoner subsequently accommodated as tutor pursuant to screening process, decision was taken to review this order, where the direction was issued to pay the salary.
Yes, what is the ground for review?
The only ground for review is, my lord, the subsequent development.
Like what?
Like, my lord, the petitioner, as I mentioned in the additional affidavit also, my lord, during 1889 to 91, there is a large scale appointment in the state of Assam, which are not again sanctioned posts without any advertisement. So those cases came to before this Honorable Court, and Honorable Court directed the department to take a decision. So accordingly, a screening committee was constituted in the year 2012, and that screening committee, the petitioner also, since she was also not receiving the salary, she also participated in the screening process. During the pendency of that petition, she participated in the screening process, and finally, a report was given to the government by the screening committee, where there are 4 categories of teachers were identified. The petitioners were identified in the last category, where she was working, her appointment was illegal, but she was continuing to work, So accordingly, cabinet took a decision. Those who are continuing their work, they will be given a fresh appointment according to their qualification. And the petitioner, since he was working, and for a certain period of time, she received salary, she was given the accommodation order as a tutor. And she accepted that accommodation order, That is why this review, page 6, my lord. Page 6 of the review petition, my lord will find a ground.
The order sought to be reviewed,
Yes, my lord. That my lord will find,
7/2/17, isn't it?
yes, my lord.
Regarding area salary.
One, yes. Direction was issued to pay the salary, my lord.
Hmm.
Last
Yes,
record.
submit that, my lord. That order is available at contempt petition, my lord, annexure 2.
Yeah, I'm seeing it.
Paragraph 17, my lord.
I'm seeing it. It's
Relevant,
for me.
my lord, paragraph 11, 12 to 17, my lord.
Reduce current salary.
My lord, judgment was passed in 2017, my lord. His history is regarding 2001-2, my lord.
Court has come to a finding that the petitioner is identically placed like the petitioner in 3956
Yes, my lord.
and 3888. So similar yardstick has been applied.
Basis of that finding, my lord, those petitioners in this other writ petition, my lord, they were appointed from the same appointment letter, my lord.
They have got the salary, they now retired, my lord, they are getting pension, except petitioner, my lord. Two other 4 petitioners which are mentioned in the order dated, passed by the honorable court, my lord. All the 4 petitioners got the salary, retired from service, they are getting salary, my lord. But I have been deprived of 2000 since 2007, my lord. This review petition has been filed in the guard to delay the contempt petition, nothing more. Because they are saying the story that is regarding 2001-2, my lord. Once this honorable court has passed order, who is that authority? Who can sit over the order of this honorable court? This honorable court has passed order in 2017, my lord. That story regarding hack happened what 1990-2000, my lord. Once this honorable court has passed order, I am entitled to. That is my humble submission before. 9 years, my lord. They cannot say that first notice was issued, my lord. They appeared in 30/10/2017. They entered appearance. Took time to file counter affidavit. Contempt petition, my lord. First order is 21/8/2017. Contempt petition, my lord. Second, next item, my lord.
How many parties are there?
Only 2. 2 has retired, then newly appointed were substituted, my lord. Petitioner is single, my lord.
No, I mean the respondents. Who are
Yes.
there?
The commissioner and secretary, my lord, and director of elementary education.
Are you appearing in the contempt also?
In contempt, my lord, I'm not appearing, but I can represent, my lord, since I'm Mr.
Your Lordship order may see that Your Lordship passed a strict order against them, my lord. I took Your Lordship to the.
I can represent, my lord.
So far, no one has represented.
My lord, they have not enclosed a single document to show their abhorrement in the review petition, my lord. They have not shown, not annexed a single document. Only they have, whatever they stated in the review petition, those are totally properly not verified. Those were according to the personal knowledge of the review petitioner, my lord. This is order was passed 2017, my lord. Their story is 1992. That time I was not appointed. I was appointed in 1992, my lord. Their story is 1989. And not a single document has been annexed. There I have been selected, I have been given appointment tutor, nothing is there. Only statement is there.
Contempt you had appeared earlier also, Mr.
My lord?
Panier.
Yes, ma'am.
Mr.
How can
Panier.
I can return, madam?
No, not you can represent. You had already appeared on many occasions.
Since, my lord, I am in a review petition, I am representing that is, my lord.
I know that.
Yeah.
You see, the order dated 23/7, your name is reflected.
Yes, my lord.
You had appeared earlier also.
Yes, my lord.
So what is your reply to the contempt petition?
In contempt, my lord, we have in fact, we have filed a affidavit stating this same
Only
fact,
affidavit, my lord, not counter affidavit.
Yes.
stating the same fact, my lord, we have,
By number 3, respond number 3.
yes, yes, my lord.
What have you stated?
Same what we have stated in the review petition, my lord, that they have subsequently, she has been accommodated as tutor. That is why the order, earlier order is now is unimplementable.
They have filed affidavit, my lord, not counter affidavit, my lord. ইয়াতো লাষ্টৰ পেজ দিছো তোমালোকৰ 26 পেজ, ইয়াতো 27 পাব লাগিব। পাব পানী মেলি কেনেকে দিছে তোমালোক 27 এইটো 27 এইটো 22 এইটো চিৰিয়েল পেজটো
In your affidavit, paragraph number 2-3,
Yes, my lord.
you have shown the steps taken by you. But then paragraph number 4, you go back to 2011.
Yes, my lord.
Why?
Because, my lord,
No, it cannot be. In the meantime, issue of irregular appointment was placed before the cabinet on 26/2/2011.
while
After reaching 2017, how do you state that in the
because, my
meantime?
lord, this the 2011 exercise, the petitioner participated in that exercise, my lord. And finally, she was identified as irregular teacher, and she has been given the fresh appointment. That is why, my lord. Because process was started in the year 2011 and it was completed in the year 2020.
In the contempt petition, only one of them has filed, respondent number 3.
4 also,
4 also filed.
yes, my lord, 4 has also filed.
Where is the affidavit?
This, my lord, by the director, my lord. On 26/8,
Same date, my lord.
20,
Same date.
21st, same, no?
Same date.
Oh, 26.
Okay, so we'll hear this matter
My lord,
on a different date. Nothing else has to be filed now, isn't it?
my lord,
Nothing else has to be filed now. Pleadings are complete.
My learned friend has not,
Hmm?
my lord, I have filed contempt petition. They have not filed anything, my lord.
Hmm.
In review, nothing is to there, my lord, because they are saying the story of 2010, 11, 2000, how it can be liable, ma? How can they take the stand, my lord? On the last day, court was honorable, this honorable court was about to dismiss it. But learned friend said that I have to take some submission, my lord.
You want to file anything in the review?
My lord, review, my lord, I have got some, I want.
No, you want to file any objection to the review?
File, my lord.
Do you want to file? I'll give you some time if you want to file.
Maybe listed on next Thursday, my lord.
No, the convenient date we'll have to see,
My lord,
depending on our dates. When is it convenient?
on that day, before that, I will try to file, my lord.
17th.
My lord, 17 will be delayed, my lord. May I pray that, my lord, be on 5th, my lord. 5th of March, my lord.
Huh? 10 or 12?
My lord,
10 or 12?
13,
10 or
10.
10 or 12.
10, 10, 10.
10th of February, 10th of
10
March,
may be given, my lord. 10.
10th of March. Learned counsel for the respondent, writ petitioner, submits that he may be given some time to file objection to the review petition. Stop in view of above, when is agreed to by the parties. This matter on 10th of March 2026. Objections, if any, may be filed before the next date. Whatever objections you want to raise, you file, then we'll consider and see.
Obliged.
Yes,
Plus the petitioners before lordship were selected for the post of LP school teachers, my lord.
you have filed rejoinder.
Yes, my lord, I have filed rejoinder.
Yes, Mr. Phukan, you ready?
Yes, Lord. Lordship, this matter, we have filed our affidavit in both the case.
Rejoinder also filed.
Yes, sir. We have filed the.
So matter is ready. Isn't it?
We have filed our affidavit on 25th day of November, 25.
Yes, what is your case,
My lord.
Mr.
The
Sakya?
petitioners before your lordship were
Hmm.
initially selected on 18/8/1995
Selected as what?
as teachers in LP school, my lord.
Hmm. How many petitioners?
Your lordship will find 15 petitioners, my lord, in WPC 3783.
Hmm.
The first case, there are 15 petitioners.
Hmm?
The first case, which is 3783 of 24, that is, there are 15 petitioners.
And the
Okay.
other case, my lord,
For your
33 petitioners.
Okay, you have filed affidavit in both.
Both
Both
the cases.
affidavits have been
Let him
filed.
submit, you take your seat.
Identical affidavit, my lord,
Yeah.
same rejoinder almost, my lord.
Identical.
My lord.
You represent both the petitioners, both set of the
My
petitions.
lord. In this
Yes.
case, my lord, the select list was prepared on, my lord, 18/8/1995.
Hmm? Hmm.
Thus you will find a select list at page 22.
Hmm.
Here, the petitioners before lordship are placed as serial number. Lordship may kindly note down the serial numbers. Petitioner number 1, serial number 40,
40.
40, my lord.
Hmm.
Anupal Chaudhary.
Hmm.
Petitioner number 2, serial number 25,
Hmm.
or Peter Chakraborty.
Hmm.
Petitioner number 3, serial number 24. Petitioner number 4, serial number 45. Petitioner number 5, serial number 18. Petitioner number 6, serial number 27. Petitioner number 7, serial number 144. Petitioner number 8, serial number 41. Petitioner number 9, serial number 21. Petitioner number 10, serial number 43. Petitioner number 11, serial number 23. Petitioner number 12, serial number 62. Petitioner number 13, serial number 94. Petition number 14, serial number 87. And petition number 15, serial number 7.
This is what,
This is the select list, my lord. I have given the type copy as well as the Xerox copy of the original select list, my lord.
what was the scheme of the selection? Interview,
Yes, my lord.
no written examination.
At that point of time, no written examination was
Okay.
held.
And there was any open advertisement for this?
Yes, open advertisement was there, my lord.
Okay.
Select list, my lord, they have not denied that select list is, my lord, genuine or fake, my lord. This has been, my lord, examined by in a series of writ petition by this honorable court, wherein, my lord, this select list has been held to be valid select list, my lord. I'll take your lordship to that, my lord.
So
After the-
annexure one is a select list. Then after that,
After that, the petitioners were appointed,
when?
shall find
No, what is the date of the select list otherwise?
18/8/1995,
18/8/1995.
my lord.
Is
Appointment,
it
I have given one appointment of.
from where are you saying that?
Page 22, my lord.
Signature?
In its meeting held on 18/8/1995. Selection list of candidates who appeared in interview for appointment of LP school teachers in Karimganj district as per selection made by the subdivisional level advisory board for elementary education Karimganj in its meeting held on 18/8/1995.
Then
My lord. Thereafter, my lord, they were appointed. You shall find one of the appointment I have annexed, my lord, at page 30.
who is he?
Is the serial petition number 1, my lord. Anupal Chaudhary. Subject to police verification, Anupal Chaudhary, past HSLC, son of so and so, of village so and so, is hereby appointed temporarily to act as assistant teacher and posted at so and so LP school in the scale of pay so and so plus other allowances admissible under rules from the date of which he joins vice so and so retired. So his appointment was, all the petitioners were appointed, my lord, against retirement vacant post. Till January 1997, there was no problem, my lord. They were getting their regular salary. They were teaching in the school. Till that, in fact, they are teaching, my lord. With effect from February 1997, with effect from February 1997, the authority stopped paying their salaries.
Yes.
When the authority stopped paying their salaries, the petitioners approached the authority concerned. And the authority said that all the records of selection were seized by the department for verification of those select lists. And finally, those select lists were handed over and a consolidated statement was prepared, my lord, in the office of the district elementary education officer, Karimganj. So you will find that page 52.
52, what is this?
This is a consolidated statement, my lord. This has been signed by Deputy Commissioner, Block Elementary Education Officer of all the blocks and District Elementary Education Officer.
Is it different from annexure one?
Annexure 1 is a select list, my lord. This is a comparative list, my lord, wherein, my lord, the select list were examined by the authority. This is subsequent, my lord. This is in 24th February 2015. Select list is of 1995, man.
So what was the requirement of having gone through the to visit again the select list in 1995 in 2015?
2015, this is not a select list, my lord. This was the verification report. In fact, my lord, this consolidated statement was prepared by the competent authority, wherein those names of selected candidates were reflected. The select list, date of advertisement, selection date,
Mr.
all
Saikia,
serial numbers.
Mr. Saikia, come to the point. What is your case?
My lord.
What is your case?
My lord, as the salaries were not being paid to the petitioners and other similarly situated candidates, some similarly situated candidates, my lord, they approached this honorable court, my lord.
Hmm.
And this honorable court, the judgment law will find at page 89,
89.
my lord.
Salary stop since February 1997.
My lord.
Page 89.
Page 89, my lord. And my lord, relevant portion also will find at page 101. In that case also, my lord, 3 petitions were disposed of by common judgment, my lord.
Yes.
Page 101, lordship court, my lord. Paragraph 12, my lord.
Hmm.
May I read, my lord?
Yes.
I have heard the learned counsel for the parties and have also considered the materials on record. The fact that the petitioners were appointed pursuant to the select list dated 22/6/1992 and or the select list dated 18/8/1995. This is the select list from where these petitioners are selected. Is at fait accompli in that the consolidated statement prepared by the state authorities indicates the stand of the petitioners. The fact that the petitioners were granted salary in regular scale of pay from respective dates of their appointment until January 1997 is also not disputed. The objection now raised is that the petitioners were appointed against non-existent post and non-sanctioned post, and they are not entitled to arrears salary. This is not the stand taken by the state respondents when the petitioners had first approached this honorable court in the year 2003. In fact, although the petitioners have continued to serve in respective schools and from the year 1995-96, no steps had been initiated by the state respondents interfering or questioning the appointment orders so issued, nor any such steps were taken when the matter was sent back to the government for examining the case of the petitioners pursuant to the order dated 18/7/2003, passed by this court in the earlier round of litigation. The submission of Mr. Majumdar that appointments have been made contrary to the statutory procedure and or prescribed procedure, in that the same was not proceeded by any advertisement or participation of the petitioners in any selection process, the same do not find the support from the materials on record. To reiterate, the consolidated statement prepared by the respondent authorities discloses sufficient particulars meeting the objection raised by Mr. Majumdar. In the said consolidated statement, there is mention of the order when advertisement had been issued. The allotment of the interview number also supports that the petitioners had participated in the interview process. Reliance placed in the case of Mamta Mahanti and Nazira Begum Loskar do not come to the aid of the respondents inasmuch as the present proceeding is not a case where appointment had been made by making a clear departure from the prescribed procedure or at the behest of some unseen hands. Had it been so, the state respondents would have certainly taken action against the petitioners or would have at least issued so-called notice questioning their appointment as assistant teachers. On record, no such steps have been taken by the state respondents until this date. As the case laid out by the petitioners against the unreasonable and arbitrary action on the part of the state respondents against post view of the communication dated 16/9/2015, which had been obtained by the petitioners through Right to Information Act, the clarification made by the Deputy Inspector of Schools, Karimganj, in response to the government's letter dated 7/8/2015 abundantly goes in favor of the petitioners, at least to the extent that the selection made by the subdivisional level advisory board for elementary education, Karimganj, along with all original records had been submitted to the government way back in the year 1998, it was so done because the government W2 message dated 23/4/1998. But by this W2 message, my lord, all the records were called for, my lord.
What annexure is this? There is no numbering.
My lord. This is
What is the annexure number?
This is the consolidated statement, my lord.
No, the judgment you have annexed what?
Yes, my lord.
You have not annexed it as an annexure.
Annexure, it has been annexed, my lord.
As what? Annexure what?
Annexure number 11, my lord.
Where is it written 11? Nowhere written in 11.
In the index, my lord, I have written, but in the judgment.
It starts from page 89.
Yes, my lord, the next annexure is 12. My lord, in the judgment, it was not written. I'm sorry for that. This,
You say that you're covered by this judgment.
Yes, my lord.
What do they say? You're not covered.
They say that, my lord, the screening committee was constituted. Screening committee held that we are irregular teachers, so we cannot be given the regular scale of pay. Instead, my lord, these petitioners were appointed by the impugn orders at page 124 as tutors.
124 or 154?
124, my lord.
124
or not, my lord. Impugn orders was will find at page
I think
124 or not.
there are a lot of similar cases are there of this type.
Yes, my lord.
Adjusted.
My lord, this.
Not illegal appointment, but irregular appointment. And hence they are adjusted as tutor.
Yes. That is their stand. But
Ah.
my case is that we are regularly selected candidates, my lord. We are regularly selected candidates.
That is your case. Well, I'm talking about other cases also. There are many cases like this. There are other cases also, apart from your case.
My lord.
What has happened in those cases? Mr. Fukan, you are aware?
Some cases, my lord, I'm not aware. As for his case, my lord, other cases, I'm not sure, my lord. I'm not directly dealing with. But this
No,
case, my lord, our stand is that, my lord, they are illegal teachers. And I'll come to that one. Let him complete, my lord, come to that.
So that, of course, you'll do that. But right now, I'm on that question that there are other similarly writ petitions on the same subject matter. I've come across a number of them.
Challenging the appointment as tutors,
Correct.
my lord.
So what is the result of those cases?
I am not there. but
And
I
here,
am
my lord, he
aware.
has not challenged he has become a tutor. We have annexed in the affidavit. That particular tutor appointment which he has taken, which the 15 petitioners have taken, has not been challenged by him in this case. That I will showcase with later. If he is aggrieved by the appointment order of becoming a tutor, then he hasn't challenged that particular order. I will come to that. Let him complete, my lord.
Now, as regards your claim that you are covered by this judgment,
Yes, madam.
what is their stand?
They have not said anything, but
Annexure 11.
they
No.
have in their affidavit, they only says the screening committee says like this, and these petitioners are at my lord, serial
Annexure
number
11 is in paragraph
so-
14.
and they are not entitled to regularization and regulation.
Paragraph 14. Where is your counter affidavit? Paragraph 14.
Yes, sir. My affidavit, my lordship will find at
You have not answered parawise.
Otherwise, they have not answered, my lord.
my lord, we have given
They have
our
not denied.
we have given, my lord.
In fact, that can be presumed that
Let
they
him
have
say.
admitted our
No.
apartments.
We will let him say, my lord, then I'll.
You have violated the rules of pleadings. It has to be a specific denial or specific
We have
admission.
most of the facts, my lord.
You're writing like an essay writing.
No, my lord, it's not an essay, my lord. My lord will kindly see, my lord. We have basically given what, my lord, procedure was followed, my lord. Your lordship comes to paragraph 5 of my affidavit.
No. You tell us
Right.
whether this judgment on WPC 5032 is applicable or not.
It's not applicable on him, my lord, at all, my lord.
Where have you stated that?
My lord, it is not applicable, my lord. I'll come to that, my lord.
Where have you
particular
stated
judgment
that?
he has given, my lord, it is not applicable because, my lord, they have applied, my lord, they have participated in the screening procedure which I'm talking, my lord,
Where,
which he's talking
where
about.
have you stated that? Just point out,
Page, kindly
just
come,
point out the paragraph number.
Lordship will come to paragraph, um, yes, ma'am. Lordship will come to paragraph 8, my lord. First of all, my lord, I'll just give you the breakup, my lord. That pursuant to the report of the screening committee, which they participated, my lord, they participated in the screening committee, all of them. A decision was taken to regularize the service of teachers who falls under category 1. Now, my lord, this is very crucial because I have to give you the sequence, my lord, as to how this thing happened. So first of all, my lord, what happened was, if your lordship comes to again, first, my lord, will come to paragraph 5, my lord. Here, my lord, in compliance of the order dated 2/3/2010, passed in the Honorable Court's decision dated 1048 of 2004, the Education Department placed the matter of regularization of irregular teachers, my lord, in its meeting dated 26/2/2011, my lord. Thereafter, my lord, my lord, that in response of the said advertisements for screening applications were received from illegal appointed teachers throughout the state. After conducting preliminary examination at the directorate level, the elementary education wide notification dated so and so constituted 5 committees, my lord, of different districts, my lord, which is given here, my lord. That is, my lord, the BTC to examine these applications and report of that is in the 6th schedule. And then 5, my lord, screening committees, Upper Assam Division, Lower Assam Division, North Assam Division, Hills Barak, and BTC area. Now, my lord, what happened? Thereafter, my lord, divisional committees verified the applications and their reports with recommendation views to the government for further action. However, due to complaints from various corners, my lord, a re-verification was conducted. So, my lord, after a re-verification was conducted in some of the districts, the respective screening committees, after causing re-verification, submitted their reports to the government. After verification of the reports of the divisional committees, the following categories were made, my lord. So, there were 4 categories initially, my lord. The first one was recommended and working till date. There were 136 number of people, teachers, working, recommended and working, my lord. Thereafter came, my lord, number 2, recommended but discontinuing. There were 250. Then, my lord, not recommended but working till date, the 8,470. Then came, my lord, not recommended and discontinued jobs, 2,900. Now, your lordship will see that pursuant to the report of the screening committee, a decision was taken to regularize the service of teachers who falls under category 1, and subsequently their services were regularized. So, my lord, these people, my lord, then after that, my lord, with regard to second category of teachers who were recommended but discontinued, the question of regularization of service and payment of salaries does not arise since they are not in service. Similarly, in case of fourth category, since they have discontinued, consideration of their cases for regularization and payment of salaries does not arise. In respect of third category of teachers who were not recommended but still in service, the state respondents had decided to issue individual show cause notice to all the 8470 candidates and 766, including 752 terminate teachers of Dhemaji and Lakhimpur districts respectively, indicating therein to show the reason as to why the appointments are not deemed to be irregular or illegal, and as to why they should not be removed from service for being appointed in violation of the existing rules. Now, my lord, will come. This part is crucial. 9. Paragraph
Okay,
9.
Mr. Fukan.
However, my lord, if your lordship, if I can complete it, my lord.
We'll fix the matter some other day
My lord.
for hearing.
My lord.
Mr. Saikia. It is submitted by the parties that the pleadings are complete and the matter can be taken up for admission hearing. As agreed to by the parties, list the matter on so and so. 17 March.
After 23.
Huh?
So, kindly give it after 23, my lord. March.
23 of March.
After 23rd March, my lord.
Oh, okay. On 2/4.
Item 12.
I pleased your lordship, matter pertains to non-payment of family pension, lordship. Pension papers forwarded to respondent number 5, lordship. Kindly perused page number 29.
Yes, you are appearing for BTC.
Lordship, I appear for BTC, my lord.
What is
We have
your
already
response?
done our part, my lord. We have already sent the original service book and relevant documents, my lord.
To whom?
Director of pension on 9/9/24, my lord. There,
Okay, 9924.
lordship. Thereafter, my lord, the director of pension had asked the DEO Pokrajar, my lord, the present respondent number 7, to resubmit the same, but from 9/9/24 onwards, my lord, the original service book and relevant documents are with the director of pension. And since, my lord, pension is not the transfer subject, my lord, so it will be governed by the state, my
9924.
lordship.
That was even before filing of the petition.
Yes, my lord. And the claim of the
But you have
petition,
not even filed counter affidavit. From where you are seeing that?
lordship, I have the instruction.
Why don't you file that in the form of an affidavit?
Yes, my lord, that we can do.
4th March 2025.
5, man.
We
Yes.
have
it's
returned
fine.
we have sent it on 30th March 2025. To the district elementary education program.
13 March.
13 March 2025.
Yes, what have you sent?
The original service book.
Kokrajar, for why? Why?
Because,
Some clarification.
yes, resubmission the pension proposal after obtaining the relaxation of the rule 205 and 6 of the Assam Service Pension Act 1969.
But it has to be granted from the state, man, from the director of pension, it will go.
So we have received a letter on 4th March from the district elementary education officer regarding return of the original service book. And on 13th March, we have returned it. After that, March, I think after them, I got the elementary BDC authorities.
Lordship, a copy of this instruction may be provided to me. I'll take updated instruction.
This is the problem, you see. You get instructions and you keep the paper with you in the file. You don't file it. File it in the form of an affidavit so that everybody shares the information.
24th February 2025, there was a direction the DEO to appear before the court virtually. And on 6/3, my lord, we have received the instruction that original pension is required to be sent back to the court. And accordingly, on 13th March, we have sent it back. So it is up to the education and the BDC authorities. Let my friends from BTC obtain the up-to-date instructions.
Yes, madam. A copy of the
Yeah,
instruction.
give him your copy. Your good name, please.
B. Bora.
Ms. D. Bora, learned counsel appearing for the BTC respondents. Praise for and is granted a week's time,
Week's time.
2 weeks' time to obtain the up-to-date instructions in the matter. This again on so and so.
Come on. 30.
Yes.
May I please, your lordship? Lordship, we have some instruction from the petitioners. We want to bring it on record, lordship. Kindly grant us some time. We'll file rejoinder.
What is that instruction?
Instruction.
Some development.
Yes, lordship, we'll bring it on record.
But what is that? You tell me. What do you want to bring on record? At least tell me so that we can write the order. What do you want to bring on record? It must be having some name, na? What do you want to bring on record? It must be having some name. What is that? Hmm.
Lordship, actually, that is not with me, with my senior, Mr. A.R. Bhaiya.
All right, but at least you tell me, what is that? Is it a development
No,
in the matter?
actually, he was there, but due to some personal difficulties, he had to leave the court.
No, that's okay. I'm asking you, you want to file an affidavit. I'm asking you for what purpose? What kind of affidavit you want to file? Rejoinder affidavit? Or to
Rejoinder.
bring on record some recent development? What?
Oh, Lordship, he just told me about this.
He just
That
told you
he-
about what?
He had some instructions with him. And he want to file rejoinder.
Rejoinder?
Yes, Lordship.
I see that. If it's rejoinder, then it's a different thing. Learned counsel for the petitioner prays for and is granted 2 weeks time to file rejoinder affidavit. List again.
40.
May I please, Lordship?
Yes.
Lordship, the matter pertains to suspension, Lordship. Should you kindly find at page 13. This is the impugned order, Lordship.
Page
Page 13.
13. You are still under suspension.
I am under deemed suspension. I have been under suspension since last 5 years, Lordship.
Last 5 years.
Last 5 years.
You're getting subsistence allowance.
Yes, yes.
You're getting subsistence allowance.
Subsistence allowance is not issue, Lordship. Yeah. I am getting that.
Then what is the issue?
And page, Lordship, page 14, next page, Lordship. This is the bail granted by the learned court below, Lordship. Soon after getting the bail, I have intimated the matter to the concerned respondent authority. But
In the year 2025, my lord.
21.
Petitioner has received granted bail in the year 2021,
Hmm.
but he has informed the authority only in the year 2025. There is no whisper in the petition also, my lord.
No, petition is,
Can you see
there is a categorical statement in the petition.
No, from where you're saying that information given only in 2025?
My lord, here, kindly see page 8, para 6, my lord. In his petition, my lord, petitioner begs to state that he made an reference before the block limited education, singing money on 19/3/2025. Praying for withdrawal. Prior to that, he has not made any, my lord, representation before the authority, my lord. That is reflect from, my lord, annexure 3, page 16, my lord.
No, this is for withdrawal or suspension
My
order.
lord, but. he
You are
has-
saying that information given only in 2025.
Yes, my lord. Kindly see-
Where is that?
That is not there, my lord.
Then,
To my
if
understanding.
it is
my lord,
not there, why do you make up stories like that?
Well, he has not stated anything in the petition, my lord.
No, you have stated so. He has given information about his bail only in 2025. That is what you stated. Where is it written?
Well, that instruction, but I don't.
No,
have
no,
that.
you don't make statement like that. That's what you stated.
From the petition, I'm just making this statement.
From the,
From the petition, my lord, of the.
show me in the petition, where is it written?
Well, he has only stated that he has made his prayer for withdrawal of suspension in the year 2025 only.
Withdrawal or suspension is one
Well-
thing. Information regarding bail is another thing,
My lord,
isn't it?
my lord. But. he
So
has-
you're adding all those things
Well, he has
yourself.
not submitted any bail order of this bail application before the.
No, you have not submitted any counter affidavit and you are arguing like that.
I'm.
You have not submitted any counter affidavit and you're arguing on the basis of the statements made by the writ petition himself.
No, sorry, my lord.
What value does it have? This is the trend I've seen. You will not file counter affidavit, you'll produce one small piece of paper and say that this is the instruction and you'll submit from that.
Lordship, may kindly find at page 17, Lordship.
Thing is that if a writ petition is filed, you file counter affidavit, raise all the issues which you have to raise.
Right.
And the counter affidavit better be in the form of a proper affidavit, specifically denying or admitting, not like essay writing, story writing. So you are under suspension from the day of your arrest in
From the day-
2020.
From the day of my arrest, Lordship.
You are regarding subsistence allowance, no issue, you're getting.
I am getting that.
But you have not been
But till
reinstated.
date, Lordship, my submission before your Lordship is that no memorandum of charge has been issued to me.
Okay.
And no review of periodical review, what is required as per the established principle of law.
Yes.
Nothing, no periodical review has been done till date, Lordship.
What happened to the criminal case?
Criminal case,
Charge
Lordship,
sheet filed?
not begun at present. So for my instruction, it is at appearance stage, Lordship.
Appearance stage.
Appearance stage.
So can you put a person in under prolonged suspension like that
No,
without reviewing it periodically?
to my understanding, but he has not informed the authority that he has released from the jail, madam. That is why I think so, madam. But because, madam, that is not reflect,
Lordship,
Mr.
kindly-
Counsel,
Lordship.
information specifically is not given,
madam.
but
Lordship, kindly-
in the yet, just a minute, I'm arguing on your behalf. You don't interfere like that. But he has filed writ petition last year.
Madam, I have not received any instruction.
He has filed writ petition last year.
Yes.
Enclosing bail order, everything.
Madam,
Now you know that he's on bail.
madam,
What are you doing?
regarding this, I have to take instruction.
That you take, nobody is stopping you. Take instruction. Don't say that you never informed the person, the department. Maybe directly he has not informed, but by filing this writ petition and closing a copy of the bail order, you know he's on bail now.
Yes, madam.
So what is to be done?
Some time may be granted, I will bring the instruction.
Criminal court may end up in acquittal also, we don't know. Or he may be discharged at some level. You are working as what?
Assistant teacher.
Assistant teacher. And your allegation is against under what provision of law? 302.
147, 148, 149, 326, 302.
All serious charges.
That incident happened nearby my residence. That's why my name was implicated there.
Petitioner is aggrieved because of his prolonged suspension since 9/11/2020, on which day he was arrested. Stop. The suspension order has been passed by order dated 27/11/2020. And the respondent authorities has neither reinstated him into service nor reviewed the suspension order. Stop, Mr. P.K. Bora. Learned Standing Council. Elementary Education Department, appearing for all the respondents, submits that the petitioner himself has not informed the respondent authorities about he being released on bail. Next para, be that as it may. The petitioner has, since the petitioner has filed his writ petition enclosing a copy of the bail order in the year 2025, the respondent authorities by now should be aware about his release on bail. So they are therefore required to justify their action as to why the petition has been kept under prolonged suspension till date. Stop. Mr. P.K. Bora prays for and is granted 2 weeks' time to receive instructions. List again on so and so.
Authorized.
For hearing item 29.
My pleasure.
Mr. Nath, yes.
This is a quite.
Is it a short matter?
Not very short matter, but I'll try to finish it to make it as possible as my lord, short.
Who's for the other side?
Mr. K. will be appearing in this meeting.
Who?
Mr. K. Gugoi.
Go ahead.
He's on legs in another court.
Let me continue in the meantime, because you also told me,
He'll be joining very soon.
yes, I've not said. My lord, let me just tell the background of the case, my lord, because this is, since my file is quite hefty that way, my lord. The petitioner was working as university engineer in Dibrugarh University. So there's, the authority were supposed to make 2 guard hostels. So to constructing 2 guard hostels, my lords, they wanted to fill up certain low-lying land. So for low-lying land, my lord, the PNC committee, Planning and Construction Committee, and the authorities of the university, they have resolved that and sanctioned, approved also, that 2 hostels will be constructed and for which the land will be filled up.
Petitioner is working as what?
University engineer.
University engineer.
Engineer. She's the engineer. She does the looks after the construction part and all
She?
this. Yes.
She.
She,
I
my
see.
lord.
Okay.
So in terms of this, my lord, something happened. She was placed under suspension. This honorable court interfered with the suspension order. After she was reinstated, again she was put in suspension. Again, lordship interfered, my lord. It was, my lord, set aside. Then the department proceeding started. Then she was removed from her post, my lord, termination. Again, your lordship has initiated, my lord, set aside that order, my lord, with the direction that since she has filed her representation against the inquiry report, so from that point onwards, the authority will look into the representations and the reply and will pass an order in terms of the law. So after that, this matter, and thereafter they have done it, they have removed her, my lord, from the post, terminated her, again we filed the writ petition, my lord. That's the case, my lord.
Now, this is the 4th writ petition.
This is the writ petition.
Fourth
Fourth petition, exactly. Lordship, absolutely right, my lord. 4th petition, this is. So, lordship, shall I take you the list of dates? As the lordship pleases. Because lordship list of date I have given, and also I have submitted my written argument along with the page mark, so that lordship become convenient to a dictation.
You are basically challenging the removal.
Yes,
Removal
removal,
dismissal.
Removal, my lord. Yes, yes. Now, if your lordship kindly see that, let me take your lordship to the charges, my lord, first. Then you will know, my lordship will know what happened actually, my lord. Because basic thing is the charges. From the charges, my lord, everything went up to my lord. There's a disciplinary proceeding, and then there's an inquiry, all these things, my lord.
So before that, you have enclosed those orders passed in the earlier.
By this honorable court, my lord. Yes. Lordship kindly say, page number, my lord, 18. Page number 18 first. Page number, annexure 18, page number 95. Page number 95.
This is the first writ petition.
First writ petition.
95.
Yes. My lord, if I take a lordships to, let's say, 3 pages order.
It's okay. You don't have to read it. I just wanted to know the
last part, page 98. Start in page number 96. My lord, lordship can one thing, my lord. This should be reported to them. My lord, can I do one thing?
Yes.
It will be easier, I think, to note down. I've given list of dates, my lord. Can I read this one? It will be easier for your lordships, my lord. List of dates. As it pleases.
No, you did. You just show me.
Order. Okay.
Just show me the order and the page number.
My lord. Page number 98 is the operative part.
No, the 95 is the first writ petition, isn't it?
Yes.
5617.
First order passed by the court.
Disposed of on 6/5.
Yes, that's on 6/5/2015.
Okay. What is the subject matter of this?
My lord, she was placed under suspension.
You have come against the suspension.
Suspension order, my lord. That was in violation of their ordinance, my lord.
Oh.
So, the honorable court in page number 98, my lord, the operative part.
Reinstated, to be reinstated.
Reinstated, my lord.
Then the second writ petition.
Then the second writ petition, my lord, again, page number 100.
Page number 100, that's on dated 19/5/2015. 19/6/2015. The operative part in page number 103.
What was the subject matter here?
Again, suspension, reinstated and again paid a suspension.
Again suspension.
Yes, so lordship again interfered in this case, my lord.
Then again court.
Yes.
Reinstate. Okay, then the third one.
Third one is page number 228.
220.
The disciplinary proceeding initiated, she was terminated, and then against that, my lord, that petition was filed. 228 page number. That's dated 28/3/2018. Page number 228. This is important because from here, my lord, fourth case started. Now, if your lordship come to page number 237, because the relevant part starts from here,
Yes.
the ending part. My lord, paragraph 19, let me read from there. In such view of the matter, as the show cause notice against proposed penalty was not issued to the petitioner before passing the order of removal from service, this court is of the view that procedure adopted by the respondent authorities is in deviation of the statutory provisions of Ordinance 2000, and as such same stance vitiated. Further, it is also the position of law that when delinquent employees give a reply to the inquiry report, said reply is to be given a due consideration by the disciplinary authority before passing any order of penalty against the delinquent. In the instant case, it is noticed that although the reply given by the petitioner against the show cause notice was shown to have been sent to the members of the Executive Council, but apart from bland statement in the resolution number 14, that the reply given by the petitioner does not disprove the charge against the inquiry, no other material has been brought on record to indicate that disciplinary authority had given a due consideration of the said reply. From the said point of view also, a procedural aberration is found to have in the method adopted by the respondent authorities in arriving at the order of removal from service. For both the reasons as indicated above, the order of removal from service dated 24/10/16, as well as the resolution number 14 of the Executive Councils of the Divisional University in its such and such meeting held on 24/10/16 are set aside. As the interference is made on the technical aspect that required procedure has not been followed, it is provided that in the interest of justice would be met if the respondent Divisional University now proceeds against the petitioner from the stage where deviation from the established procedure had taken place. Accordingly, the Divisional University shall give a consideration to the reply of the petitioner submitted against the show cause notice dated 5/7/16 and arrive at a reasoned conclusion as to why the reply should not be accepted, and thereafter proceed with the requirement of proviso to Article 332(4) of the ordinance. It is clarified that the implications of the order of removal being set aside is that the petitioner stands reinstated in service, but thereafter authorities can proceed against the petitioner as per law, my lord. Thereafter, my lord, after this, they've considered according to them the representations and they passed the impugn order, my lord. They have taken resolution. That's in page number 239 NHR 8. 239 NHR 8. This is after the High Court Honorable Court's last order dated, my lord. NHR 26, page 239.
Resolution dated 23rd April.
This is dated 23rd April 2018.
Then order passed.
Then order, the decision was taken, my lord, in page number 245. Decision was taken, my charge-wise decision. Charge-wise decision, lordship will find from next page 239, 40, 240. Yes.
What was the what was the recording of the
My lord,
resolution passed by the EC?
EC, my lord, the operative part, my lord, they do not agree with the, my lord, the reply submitted. So ultimately, they have resolved, my lord, page number 245, kindly see,
245.
245.
This meeting is entirely with regard to the petitioner
Yes.
or different other subjects also?
No, this is for the petitioner.
Only for the petitioner?
Yes. Because in page 39, lordship can find item number 1, to consider discussion and to take appropriate necessary action, bottom, against Dipali Fukan, University Engineer, in the light of the verdict of the Honorable Gauhati High Court by the order dated such and such. So this is the resolution. Now page 245, my lord, kindly see. There is a regarding decision in top, the resolution 1, resolution 2, my lord. Then in the middle, resolution number 3.
Yes.
Resolve that Executive Council proposes to impose, before that, my lord, first decision. Resolution number 2. Resolve that upon thorough consideration of the charge imputed, the evidence led, the report of the inquiry committee, and the reply thereto furnished by the charge officer, the Executive Council is of the unanimous conclusion that charges imputed against the charge officer are proved, and accordingly appropriate penalties to be imposed on her. So this is the decision. Next part. Executive Council, while considering the gravity of the offences and the quantum of punishment, was of the opinion that if the guilty person with such dishonest mentality is not punished, keeping in view the culpable misconduct of not following the established procedure, causing financial loss to the university, then it may have an adverse effect on other persons and system of working in the university. It was further consensus view that her retention in service would not be in the interest of the university. Therefore, Executive Council unanimously agreed that penalty of removal should be suffice the cause, my lord. And thereafter, my lord, ultimately, they have removed her from the post, my lord. Lordship can see, my lord. Ultimate order of removal, my lord.
Page?
Page number, my lord, that will come. Submitted reply, page number 200, my lord, 65. 265. Lordship, may please come to that. My lord, 250, please come, 250.
$250.
250. Before that, there is they given a notice, 249, previous page, 249. Notice dated 27/4/18. This is a proposed penalty they are going to impose, so that's a notice, my lord. Page 29, 27/4/18. Notice as per proviso to Article 32(4)(6) of the University Service Ordinance, my lord. My lord, third paragraph. You are therefore now called upon to show as to why proposed penalty of removal from service should not be imposed upon you. That's what, my lord. Against proposed penalty, my lord, I have submitted my reply, my lord.
Where's your reply?
My lord, my reply proposed penalty 251 page. Is annexed 30. It should be 18/5/18, wrongly typed as my lord 12/6/18. It is 18/5/18. Bottom, there is a receipt left side, page number 251. 251, bottom left side, there's a date, 18/5/18. That's the date. This is against proposed penalty.
Your reply?
Yes. Two replies. First is against inquiry report. Second, once they have found that I am guilty, then they gave me a notice, my lord. That is as per the ordinance. I'll come to this part. Let me show you, lordships, my lord, serially, that charges first. The basic issue.
18/5.
My lord.
Your reply is 18/6 or 18/5?
This is 18/5/18. Bottom left side, there is a seal, my lord. Kindly see. This is my mistake, actually, it has come. Bottom, there's a seal 18/5/18.
There's a seal, but date is there, what?
Date is there, yes, beyond 18/5/18, date is there. Just the seal, left side of the seal, page 251.
receipt,
Handwritten.
handwritten receipt, and then date, their date, official date.
Is it 5?
Yes, 18/5/18.
It's not very legible in my copy.
Yes, 18/5/18, my lord.
Then the imprint order.
Then, my lord, page number 265. Page number 265. They've considered the reason representation reply.
267, I think.
265, yes. Ultimate decision is the 266. And the, my lord, formal order passed by the registrar is on 267. Resolution is page number 265 to 266. Resolution.
This resolution is after the filing of your reply.
Yes.
They have taken the resolution again.
Yes, my lord. Yes. Five. Below. This is. It's 4/6/18.
Yes.
6/18. Lordship will find one thing, my lord. There's a date. There's a mistake by them only, in fact. The date I'll show to your lordship, my lord. Date
of removal is 4/6/18.
Yes, 266. Because 200, this is my lord, this 16th March 18 is not correct what they have given the date. Page number, please come to, my lord, page number 239. There's a mistake they've committed actually. That's why there's a confusion. Page 239, the resolution dated 23rd April. Let me clarify this, their mistake. 239 resolution dated top 23rd April.
Yes.
My lord. But High Court has sent the matter on 28/3/18. This cannot be. So this date, lordship will find, my lord. The resolution they have taken, my lord, 16th March, page 265, please come, my lord.
Yes,
265, extracts of the minors, my lord. Lordship is found 265.
Yes.
Now, there also the mistake. Held on 16th March 18 and it is signed on 4/8/16. 4/6/18, bottom next page. Anyway, my lord, this is the date mistake they've committed. I don't know how. It cannot be 16th March 18 because Honorable Court has sent the matter back on 28/3/18. It's signed at the bottom. Lordship, kindly see of this page 265 at the bottom, my lord. This is signed, they are signed 4/6/18. 265 page number, bottom.
Yes.
Absolutely. Yes. So the decision taken on 16th March cannot be. They are also, my lord, I have non-application of mind. I'll show one by one.
All right.
And the MP in order also, 267, formal order. It's dated 4/6/18. 4/6/18 is okay. But meeting was not on 16th March. It was 4/6/18. I hope I am clear, my lord.
4/6/18.
Yes, 4/6/18.
Meeting on 4/6/18
Yes,
and
yes. So they-
imprint order of removal also 4/6/18.
Yes. They still speak about the my lord application of mine. My lord. Now, lordship may please come to the relevant part, my lord. Just for lordship, cursory, my lord. For the charges, my lord. Lordship will suffice to see the charges.
Where's the
Page
charge?
43. Page 43.
43.
Let me read 1 and 2 charges. Page 43, only 43 charges. Annexure 1. Prima facie will show something, my lord. Their question and their answer in their document.
Yes.
Charge number 1. Let me read, my lord.
Yes.
While you were holding the post of University Engineer, Planning and Construction Branch, Debrugad University since 3304, you have committed gross irregularities and deliberately
in breach of duties, responsibilities delegated to you to manage all the matters relating to the planning and construction branch, Dibrugarh University. You dishonestly and without any sanction, this part, Lordship Member, sanction from the competent authority allotted 2 numbers of earth filling work relating to developing and raising of land for the proposed construction of the hostel building of Dibrugarh University Institute of Engineering and Technology, which resulted huge financial loss to the university. What it says? Without sanction. The next 2 also. Let me read, my lord. Then I'll show in one, show my lord the reply. That while you were holding the post of engineer, planning and construction by Dibrugarh University, you illegally issued work order to 2 contractors by number such and such for an amount of such and such without following due procedure for allotment of contract work. The total amount of your illegal allotment contract work amounted to rupees 33 lakhs. From verification of the available records, it was found that you have not invited tender or earth filling work or allotted such his amount. Man, this is what. Number 1 charges, without sanction, I have allotted the work. Number 2, there's no tender. Please come to page number 198, my lord. Please. They said no sanction. Kindly, please come. 198, page number 198.
198.
Yes. Lordship has got it?
Yes.
This is one the work order, my lord. I have given it to Rajkumar Das, contractor, dated 21/3/11. My lord, bottom is my signature, university engineer. Kindly see. Left side, my lord, kindly see. Approved amount 16 lakhs. Left side. 1/9 PC board meeting, resolution 33. Copy to Vice Chancellor, register. Now please come to my lord, page number 190. 190. My lord. This is the resolution. It starts from page number actually 187. The operative part I'll show. Page 187, kindly see 109th meeting, which I have referred in my letter work, which was issued by me. Page 187. In work order, I have mentioned 109th PC meeting board. Now please come to 187.
Yes, 187.
Minutes of 109th meeting of the Planning and Construction Board University held on 8/3/11. Professor K.K. Deka, Vice Chancellor. Professor P.K. Bhuya, registered, got Dibrugarh University, and such as engineer. Now please come to page number 190. 190. 190. The charge and the can you see what is it? Resolution number 32. Resolve that estimates rupees 16,89,000 only for development of construction site for the proposed construction hostel number 1 Dibrugarh University will be approved. Resolve further that expenditure shall be made from Part 3 infrastructure development fund duet, and at least 1 feet on top will be earth fill. Next, these 2 hostel buildings I said, my lord, this is the resolution. Resolution 33, resolve that estimate will be such and such will be approved. Resolve further that expenditure shall be made such and such earth filling, my lord. Lordship has seen this, my lord. Now, please come to page 191. 191. Bottom, see the signature. Whose signature in the meeting? Vice Chancellor, Chairman of Planning and Construction Board. Then confirmed in the one meeting, this is K.K. Deka. Then register. All the officials are there. That was the result was there, my lord. Now, my lord, please come to 120. Now, one minute, my lord. This is lordship has seen. Now, charge number 2 also. Please come to 193. 193, my lord. It starts from page number 192. The answer to the charge number that without any tender, my lord, I have allowed the work. The answer is here. Page 192. During the departmental proceeding, my lord, Sanjeev Kumar Sharma, 192, was he is the office assistant, my lord. He is the office serving as assistant registrar examination of the university. Sanjeev Kumar Sharma. He is the Dibrugarh University staff, my lord. What he said, my lord, please come to page 193. I used to be present in the PC board meeting to assist the officers with records. I can remember that in such meeting, when the discussion took place regarding the construction building of the Duet campus, the then Vice Chancellor rigorously insisted that works must be completed as early as possible so that the students can be occupied those buildings by the start of the new session in the month of August 2011. The wish of the Vice Chancellor, as aforesaid, was appreciated by all members present in the meeting, as well as university students. Accordingly, the work was sought to be completed at a faster pace. I was also involved in completing the process of execution of the work in any way, and my duty was only to check and forward the bill when those come before me. Then next chapter is important. The then Vice Chancellor, who happened to be the chairperson of the PC board, used to issue verbal instructions to the university engineer, me, to immediately start the work, including the connected art filling work through the contractor who had chosen for carrying out the construction of the building. My lord, here let me clarify it. I given the work to those persons, my lord, who has constructed the building, my lord. They are registered contractors of the university. The Vice Chancellor himself at times instructed the contractor who have been allotted the work to go ahead and start the work immediately without waiting for formal orders. Kindly see. In the meeting, Vice Chancellor, everybody is there. Next, my lord, kindly see cross-examination. 1 to 3rd paragraph, the 4th paragraph. The time period during which the work was completed and the bills were finally paid, taking the data of oral instruction of the Vice Chancellor to go ahead with the work, as the initial date was about 1 month. Now, my lord, lordship, in this part, there is a contractor also, my lord. There's a contractor. He's also said the same thing, my lord. Sanjeev question evidence of Manoj Kumar Bai. Now, kindly come to my lord. Copy. Page 256. My lord. Lordship has come to 56. This is the statement I have made. The contractor whom work was given, my lord, look what he says, my lord. Just have a look. This is what, my lord. I am defense witness number Manoj Guhai. Work was given to him also. Manoj Guhai. Shall I read, my lord? Because this is in the record. Shall I read, my lord? This is important. Because one is the official you have seen, my lord. Lordship has seen. In the meeting, he said, Vice Chancellor instructed verbally. He is the contractor. What is he? Same thing. I don't know what are the charges leveled against Srimati Dipali Fukon, university engineer, but I have come to learn that regarding the art filling of the site for the boys hostel outside such and such. I received a work order on 21st March 11 for doing the art filling work of one of the sites for the hostel building. According to the work order issued dated 21st March 11, I was awarded the contract of art filling work surrounding hostel building number such and such. About 1 month prior to the issuance of the work order, I was verbally asked by the Vice Chancellor, then Vice Chancellor of the university, to execute the work, and on the basis of that verbal instruction of the Vice Chancellor, I started the work. Lordship has seen this, my lord? So the charges, first charge without sanction, it was in the meeting, my lord, PC board meeting, decision was taken, it was approved that this work will be done at the cost of, my lord, this much amount. Subsequent charges without work, like without tender, who have given the work? In the meeting, Vice Chancellor was telling the time is very short. Come on, you go ahead, give the work to the contractor, my lord. That's the reason it was given, my lord. That's on record. That lordship will find when against the inquiry report, I have submitted my reply. These are all in the representations. Because lordship is directed earlier, they will consider my representations. Do you know, from that stage they will start. So those facts were pleaded in my reply, my lord. And also, my lord, lordship may kindly say another thing. In page number 43, charge number 3. Charge number 3 is similar to charge number 1 and 2, my lord. Page 43. I'm just trying to show, my lord, What are the charges? How they have made it, my lord? Am I so guilty? Charge number 3 is just like charge number 1 and 2. You have committed gross violation of your authority by issuing work order of the earthwork to contractor without taking prior approval from the authority university in a planning question board. The answer, Lordship, I have read it, my lord. It is the vice chancellor of the meeting. They've approved it. Office of the vice chancellor, he said yes. Vice chancellor instructed. The contractor said yes, started, my lord. Now please come to page number 44, my lord. That is charge number 4. In gross violation of your page 44 of work order issued by you as a supply item, totally illegal, unjustified, you issued the ulterior motive. My lord, the work order which I have issued, page 198, interesting, my lord. 198, kindly see 198 page number. 198. These are the few pages I'll show, and then, my lord, I think legal argument will be there. 198. 198, kindly see, my lord. (198) work order. See the heading. Development of construction site, subject, my lord. Rajkumar contractor. Development of construction site for the proposed construction hostel building of such and such. You are required to supply the following materials immediately. You will be paid such and such. Description, kindly this part, kindly see, my lord. Now, lordship, keep this page, my lord, and please come to page 276, please. Keep this hand in one hand, my lord, and please come to 276. Just one comparison, my lord. (276), lordship, got it, my lord?
Yes.
Identical order. Subject and the description of the work. Raising low side with approvable soil obtained. Same thing. Low side around the building with approvable soil obtained. Everything same. Everything same, my lord. This work order issued by the assistant engineer. I am the university engineer, and page 276 is the assistant engineer of the university, my lord. Page 276. Absolutely identical, like me. Same with page 277. Absolutely identical. Nothing. There's no difference. Left side, my lord, if your lordship kindly see description of the item. Same, my lord. This is the procedure they follow in the university. Your lordship will see in the inquiry report. I'll take your lordship there, my lord. Same. For this estate engineer, everything is fine, my lord. It's super fine. So far, I am concerned. Now they say that is the, my lord, I have committed illegality. In deviation of the ordinance, I have done it. University rules. 276 to 77. Page number is identical to page number, my lord, 198 to 199. My orders are 198, 99, and assistant engineer's order 277, 76, 77. Absolutely identical. There's no difference between the two. This is the practice, my lord, in the university, my lord.
(198).
Yeah,
Is-
198.
Is the charge against you?
Yes.
And 276?
The two work order. 270 is not the charge. I showed the comparison. This is the system being followed in university. 198, 99 orders issued by me.
276?
And 277 is by the assistant university engineer.
No, why have you annexed this?
I have shown to you. When I issued this work order, they said it's illegal. But the university system is like this. Same work orders, like my lord, similar work order issued by the assistant engineer, 277. This is the system I want to say. Identical orders.
Okay.
Because there is no guideline specific, my lord. Just keep it, my lord, lordship. Now, my lord. So this is what now. Another thing, my lord. When the inquiry, all these things, charges are similar. 1, 2, 3 are similar to 5, 6, 7, 8, my lord. Like that, my absolutely similar. All the answers are there. Now, when the inquiry was conducted, Lordship will find, my lord, the inquiry report. What are the observations being made? Lordship may please come to page number 129. Inquiry report. That's very important. 129. Observations. And the inquiry report starts from page 105 to 132 up to. Starts from 105. Relevant part 106 to 105 to 132. Now, regarding the charges, my lord, they have written, my lord, one simple example I shall notice, my lord. Page 120, please come, my lord. Page 120. Charge number 1. Lordship is aware now, without sanction, other things, they said. Page 120, charge number 1, that's the recital. And page number 121, kindly see the middle. 120 in the middle. Charge number 1, therefore, stands proved in the inquiry report. Lordship has got it, my lord. Page 121 in the middle, just above charge number 2 and 3. Third line. Charge number 1, therefore, stands proved, established, in our opinion, because of such illegal, arbitrary, such and such. Lordship has seen this, my lord?
Yes.
Similar thing, Lordship will find, my lord, in charge number, next charges 2 and 3, my lord. 2 and 3, page 122. Page 122, charge stands proved, established. Now, all these charges are proved, they've written. Now, please come to page number 129, very important part. What they have found in the inquiry, my lord. Observations. Let me read, my lord, that observations.
Yes.
From the materials on record and the evidence adduced by the parties before us, we have noticed certain aspects in general which would like to place here and there. The PNC board, Planning and Construction Board, my lord, PNC board, in short, PC board, is the statutory authority of the university, and Vice Chancellor is the chairperson of this board. PNC board retains the authority to monitor and supervise all types of construction works. And supervise all types of construction works of the university. Close such and such, my lord. Para 2. University engineer is the executing authority and is responsible for execution of all types of contract work under control and supervision of the PNC board. Third, PNC board approved 2 works involved in this inquiry for execution on 1/8/2021. And what is in charge number 1? Without sanction and approval. See, the board they find, my lord, otherwise, my lord. It was sanctioned. However, the board did not provide any further guideline for execution of the works, and no direction was given to the university engineer for following the tender process. The PNC board might have considered it unnecessary in view of clause 34 of the aforesaid regulations and expected the university engineer to follow fair process of execution of such work which by way of inviting tenders. However, there is no decision of the PC board that APWD should be followed for contract works, like following tender, my lord, floating tender. The university engineer given a go-by to the tender system, picked up the contractor's offered choice without supervising the work done practically in field and without maintaining proper records, raised the bill, forwarded for payment, and such and such. 5, kindly see. Copies of the work orders so issued by the university engineer were appeared to have been forwarded to the Vice Chancellor and registered in the account section of the university. However, none of these authorities raised the point as to how work order could be issued without resorting to tender process and on what basis the contractor have been chosen by the university engineer. This shows that there is a lack of vigilance on the part of the higher authorities. Next, While forwarding the bills for payment to the finance and accounts branch, it was the responsibility of the finance and account branch to scrutinize the bills and examine the relevant aspects, including the submissions of the relevant papers, documents, along with the bills, which should inevitably include tender process, comparative statement, sanctioned by the PC board, proper record of execution of the work, as well as recording of measurement in the measurement book, etc., etc. In the absence of any supporting documents, the finance department, finance and the accounts branch was required to raise objection and put up the matter to the registrar, indicating the deficiencies found in the bills for the necessary direction. And in that case, a registrar could have examined the whole matter and verified the relevant facts pertaining to the execution of the contract work before issuing orders for payment of the bills. Six, they have repeated twice, number should be 7 actually. In the instant case, it appears that finance and accounts branch did not raise any objection to the bills and or point out any deficiency in the bills and simply put up to the registrar for payment. Registrar on his part also simply allowed the bills to be paid without verifying the veracity of the bills and taking stock of the fact as to whether the works have been really done. We understand that there is an internal auditor in the university, and the university auditor of the internal auditor of the university also failed to detect and point out such serious lapses, irregularities related to financial loss to the university. We are therefore constrained to hold that there were lapses on the part of the finance account branch of the university as well as internal auditor. At the same time, there is also a lack of proper vigilance on the part of the office of the registrar of the university. We suggest suggestions. For the proper functioning of the PC board of the university authority should issue circulars laying down guidelines detailing the procedures to be followed in execution of the construction works, right from the point of preparation of estimates till the payment of bills. For this purpose, the university may adopt rules and procedures followed by Public Work Department of the Government of Assam. This will ensure transparency, prevent irregularities, misuse of authority and funds by concerned officers of the branch. The university authority may engage even on temporary basis an officer who is an expert in execution of the civil construction work for guiding the present staff of the office of the university. The university authority may also make provision for giving training to the employees of the PC board branch to educate them regarding proper procedures for implementation, execution, supervision of civil construction work. Page 132. The university authority should also issue orders specifying the duties and responsibilities of the university engineer. Can I clarify any page? Anything to clarify any page?
No. Continue.
My lord,
I've got the page.
that's why in my written argument, I've given the page mark so that Lordship can find out, my lord, the details I have given, whatever I'm arguing now. That is, say, university authority should also issue orders specifying the duties and responsibilities of the university engineer and other staff of the PC branch for better accountability and smooth function of the branch. We make these suggestions because we have learned during inquiry that because of lack of specific rules, guidelines, laying down any specific procedure for execution of work, passing of bills, there is no uniformity in executing various works and officers are left to guide themselves of their own whims.
What is this document? It's a part of the inquiry report.
My lord, 105.
Beginning with 105.
Yes. 106 is a formal letter. 106 is the report. Report of the inquiry committee.
Inquiry report ends at 132.
Yes, 132 stops. Up to that. An observation is, my lord, page number 129 to 32 with suggestions. This is important. 129 to 132. I just now I read, my lord.
Total, how many charges?
Total 10 charges. And repetition of the same charges, almost repetition. 6, 7, 8, 9, 10 charges. Yes, my lord. Charge number 10 also without sanction, without allotment, my lord. Same like. Charge number 7 is same as charge number 6. Charge number 6, measurement not supported by field book, my lord. This is one interesting, my lord. Charge number 6, it says there is no field book for measurement, but the register, my lord. Copy, extra copy. In the register, in the earlier litigation, filed an affidavit before the honorable court saying it's not required. I've got the copies, my lord. It's আমার copy, it's আমার copy নাকি? Flag mark. Just
Mr. Gogo is still on legs? Huh? Which court? Which court?
18.
18.
Part heard.
because this is matter I feel, since it's very lengthy matter, quite lengthy matter that way, my lord. In one day, I think, my lord, a little difficult will be there, my lord. Anyway, my lord, my part, I think, not very much, because I have got written argument.
What is this?
This one, my lord, please come. There's a flag in the middle. Page number 16, please come, my lord.
This is a counter affidavit.
Yes, in that earlier litigation, the registrar, what statement he gave, my lord, before this court. I just want to show charge number 6. Page 16, my lord. And before that charge number 6, let me just read for your lordship's convenience. Charge number 6, my lord. Let me just read, my lord, charge number 6, page number 44. As per documents, page 44.
Yes.
As per documents available in the bills vouchers of with MBs, it was found that measurements are not supported by field book, label book, which were found not enclosed with the bills, only to cover up your allegations such and such, my lord. The whole procedure right from the issuing work order and you're approving the bill of the contractor within 8 days. My lord, 8 days, you know, lordship, why, my lord, the reason is because Vice Chancellor said, go ahead with the work, time is very short, kister the work. Ultimately, my lord, official order passed on 8 days back. There's the reason 8 days. There's nothing wrong in that, my lord. If wrong with me, then it's wrong with the register and the Vice Chancellor also. Is this evidence of the Sanjeev Sharma, my lord? Official staff, if the finance department is said, Vice Chancellor has ordered the contractor and asked, go for barbell, time is short. Now, this field book part, my lord, in this affidavit, my lord, I just want to show. One I have given just for your lordship convenience. In page 16, line 1, 2, 3, 4, fifth line. Page 16. 1, 2, 3, 4, 5. Fifth line, my lord. Fifth line, last word there. There is no requirement for any field book or label book because measurement book which is issued in order to record the measurement of works can be used for recording the level of measurement. It is the who filed it? A registrar of the university in the earlier litigations. Second petition of suspension, second petition or third petition, my lord, just let me see this one. 2. Yes, last petition, in my last petition. There they raised the plea, no field book. Here he said there is no requirement for field book, measurement book is enough. So how they brought the charges, some reason behind it, my lord. Why these charges against me? That I'll show to you also little later. Lordship has seen this, my lord. Now, my lord. My lord, please come to page 193, my lord, once. I have read once, but one about that 8 days work in charge number 6. 193 page number.
Yes.
One month petition work by instruct the work stock copy. 1 month by instruct. Yes, in the middle, cross in the middle, my lord, bottom. 1, 2. Time of period during which the work was completed. Lordship has got it, my lord.
Page number?
Page number 193.
Yes.
In the middle, cross-examination, then first, second, third, fourth para. The time of
Yes.
period during which the work was completed
Yes.
and the bills were finally paid, taking the data of oral instruction of the vice chancellor to go ahead with the work, is the initial date was about 1 month. This is the statement of the assistant registrar examinations. His name is Sanjeev Kumar Sharma, my lord. He gave evidence. He's the one who said that vice chancellor instructed Barville, my lord, because time was very short. Nothing wrong in that, my lord. My lord. 150 million. Last part. Military intention. 155. Just 1 minute, by. Now,
Yes.
my lord. Now, this is the factual background. And now, lordship is on the earlier part litigation has given a direction to the authorities to go to the representations which I have filed against the inquiry report to consider this one. Now, that part is very important. Now, lordship will definitely, there's a query, my lord, will be where is the representation? My lord, my representation, my lord, lordship will find at page number, my lord, 133, it will be. One 33. There's another thing, my lord. Whatever I have read just now, that work order issued by me in page 198 and 199, the similar work order issued by assistant engineer. This part I have read, my lord, where in for my representations. When I wrote the representations, I gave these documents, my lord. This is what they have not touched those, my lord. Now kindly see page number 130 my representation. Now, second paragraph, let me read, my lord. PC board approved 2 works involved in this inquiry for execution on 8/3/11. However, board did not provide any further guidelines for execution of the work, and no direction was given to the university engineer for following tender process. PC board might have considered it unnecessary in view of clause 3 of the aforesaid regulations and expected the university engineer to follow the fair process for execution of such work which by way of invading tender. However, there is no decision of the PC board that APWD code should be followed for contact work. Why this is said here? Because in the APW code, there is a provision for inviting tender. And the inquiry report, there is an observation about this part, lordship has seen. Now, from the above, it could be easily be specified that PC board is responsible for placing guidelines and advising the university engineer to go in the right direction. And in the absence of this, the university engineer cannot be charged for the same, and whatever as university engineer I did could be considered as done in the interest of the university. It should be mentioned here in that Honorable Vice Chancellor being the chairperson of this board, the charge officer as an inferior has no right to override the chairpersons of the board in this respect. In the meeting, my lord, Vice Chancellor, she's an engineer, is the university engineer. See the ranking difference. Then page 135 also I've stated. Now page 135, my lord, can I take my lord? 135. The allegation against under charge number 1, against which inquiry committee reported that no tender was invited by me and I arbitrarily allotted the work order as per my own choice of contractor, completely deviating from the established procedure of allotting contract works. I would like to submit that in prevailing procedures to carry out construction work was that estimate for the work was prepared either by the firm, architect, by site in charge, and then placed in PC board for approval. When the PC board approved the estimate and after approval of the minutes of the PC board by the BC in a file, action can be taken by the engineer. Tender has to be invited for the works and comprehensive statement has to be prepared and then placed in the next PC board meeting for letter pen. But then Dibrugarh University Authority decided to construct duet building. Some practice had to be done for utilizing the government fund in short time. In item 3, in the minutes of 101 meeting, PC board approval to estimate allotment of the construction institutional building works were done in the same meeting, so that government fund could be provided, used by university, and utilization certificate could be signed. Kindly see the next sentence. Also, university engineer invited tenders for institutional building of duet before approval of the estimate by the board and as per verbal order of the BC. The duet campus where these buildings were to be constructed was a paddy field. So Vice Chancellor already verbally ordered Ardas, is a contractor, to raise the platform before construction work started. In the same meeting, PC board approved only the estimate for raising the low side. So if tender had to be invited, direction must be given to the university engineer, either by the PC board or by the authority of the university. As per clause 34 of the ordinance, tender is to be invited for construction, but raising low side by slit earth is not construction work. The Dibrugarh University has registered contractor for supply work. So Honorable Vice Chancellor has ordered Sri Raj Das, who was original contractor to construction of the building at the site, to carry out the earth filling work verbally. Therefore, work order was placed as supply work, and the copies were sent to Vice Chancellor and the registrar. They did not object about the supply order at that time and did not return the work order copy, asking the university engineer to invite tender. I could have regulated it by inviting tender notice later on, but for me, it was not proper procedure to regulate the work. However, nowadays, maximum works have been done on the verbal order for the authority, which is regularized later on as a practice by the university engineer. Now, even last para. 108 meeting held on 26/10/20. 2 hostel for duet were approved. One of the girls, my lord, in this paragraph, also may come to the bottom of this paragraph, my lord. This middle portion is not required. Last 5th line. As the area was a low-lying area with deep earth cutting, firm MS Prime Engineering was instructed to prepare estimate for earth filling verbally by the Vice Chancellor, who is approved by the PC board meeting under resolution number such and such. After getting approval from the board, PC office had to prepare draft minutes and send the same to the registrar for BC for correction. After correction, if any done by the authority, it would come again to PC office and such in the middle, after 5th line. So, to utilize the government fund for construction of the hostel properly, in the meantime, the BC ordered verbally to carry out the earth filling work to original building contractor in the respective sites before issuing formal order. Though the order was verbal, the contractor carried out the order of the authority. So supply order for these earth were prepared and copies of the order was sent to such and such. My lord. Then lordship may please come to page 138. Page 138, my lord. Second paragraph. First paragraph. As the BC is the chairperson of the PC board, he has supreme power and direct university engineer, which the university engineer has to follow. Later on, it became a convention in case of emergency that development and raising of land should be given to the original building contractor for the construction work. Here, what happened, my lord? The contractor who has constructed the boys building also is the same contractor. It is given work given to him. No, none else, my lord. They already work here. There's the reason Vice Chancellor said, give them the work, finish it. So I have done nothing wrong by obeying BC's verbal order, as he is the chairperson of the PC board and has supreme power of allotting work, my lord. Then the similar in the next paragraph, my lord, obeying such and such. Third paragraph, last line, similar example is cited in HRT with such and such, my lord. I read in page 277. Similar work order, my lord. This is the practice. So entire my representation, my lord, I have covered all these points, my lord. Now please come to once, my lord, page 154. Lordship definitely asking me question, my lord. Why it has happened to you? Why it was action was not taken against the other university engineer, state engineer, is page 76, 77. He has issued the similar order. Why against me, my lord? There's some reason why I did, my lord. Please come to page 154. I was thinking why it happened. Why they have chosen this lady, my lord? Page 154, please come, my lord.
Yes.
My lord, last paragraph. That accordingly, it can be concluded that prevailing procedure in the university was adopted for the said work done. For that perusal, I would like to cite some works which have been done in a similar way by present assistant engineer, earthwork without tendering. Assistant university engineer issued the supply order to Manoj Guhai and Sanjeev Sharma for development of rising. My lord, Sanjeev Sharma, there are two Sanjeev Sharma, my lord. Lordship might get, my lord, I get confused sometimes. One is Sanjeev Sharma is office assistant, and one is a contractor, my lord. The name is common. Here is a contractor. Manoj Kumar Guhai and Sanjeev Sharma for development and raising the land for the proposed construction of the teachers' flat at West Campus, Dibrugarh University. In development and raising of the land for the proposed construction of the academic building of such and such. But in his case, neither BC nor the present register objected to issuing such and such, my lord. Now, the such and such, but in his case, neither such. The reason for making me a scapegoat, here is the case, is that in the 118th meeting of the PC board, I raised objection against the earth filling work amounting to rupees 65,36,000 in a site for which no proposal was there for any construction work. Present assistant executive engineer intentionally gave wrong information to the PC board that the grant was received from Higher Education Department, Kahilipada, Gauhati, for earth filling work, which was later on not found to be true. The then Vice Chancellor, present registrar, and assistant university engineer made merely intention to misappropriate the money sanctioned. Later on, monitoring committee sent by the present BC also rejected the idea of land filling in that area, thus justifying my earlier objection. However, Dadi and BC was upset on my objection, framed these charges. After 2 years of completion of these works, my lord, kindly see, this is important, my lord. This is important. In 11, order was issued and Shokut issued 2013, 2 years. That's the she said, my lord. That's the reason, my lord. Now what happens, my lord? This is the fourth round. First time, lordship is interfered with suspension order. Second time, lordship is interfered with the suspension order. Third time, lordship is interfered with the removal order. Fourth time. Do your lordships believe, my lord? Unless there is a civil instruction of the judgment, they will not do. Third, they have punished me. Fourth time, my lord, unless there is a, my lord, definite order, my lord. Same thing they repeat, my lord, for this reason, my lord. So in my representations, my lord, I have submitted everything which was not considered by them in that minute lordship will find, my lord. That minute lordship will find in page number. My lord.
Mr. Nath,
My lord.
we'll continue this some other day.
I have already finished, my lord. Factual part I have finished virtually.
No, it'll take some time
Yes.
for this court to understand.
So lordship can do one thing. Lordship may keep it, my lord, because one day also it's a little difficult it will be. Lordship may kindly keep it part of my lord. No objection I have got. Because what happened earlier, my lord? This matter was hard.
That's why.
That's why I don't want to say anything on that.
Let us not repeat that.
Exactly. I don't want to say anything, my lord. My only PR is, my lord. Lordship is seen, my lord, nowadays. I'm not mentioning it's there, my lord. And I even get difficult.
Sorry?
Lordship is this in front of me, this is there, lordship is, you know. This, my lord, I'm not mentioning. Cameras and all these things, my lord. What happens, my lord, nowadays? We are so much strained nowadays because of this also. Because I know the moment I go, my lord. And that is also true. When the case was pending, she also suffered a lot. She has retired from service, my lord. But we are not on that, my lord. My humble submission is this is a little lengthy matter, my lord. It is lordship is absolutely right. In one day, it may not be possible, my lord.
Not possible.
Not possible, my lord. I don't want to stress us unnecessarily, my lord. Because when I prepare, my lord, I hours and hours a day. And in half an hour, I cannot finish, my lord. Obviously. Can a date be fixed, my lord, for that? Whenever a lordship sits here, my lord, except from 4th March to 12th March, my lord, any other date. Before that, maybe 26th.
The 4th is a holiday, right?
Yes, my lord.
4th March is a holiday.
No, I say from 4th to 12th March, not necessarily. I won't be here, my lord.
I see.
March is, my lord. 12th March possible. If a lordship is here, my lord. And if he's not here, whenever lordship come back here again. No issue.
We'll not keep it as part heart.
Lordship can keep it, my lord. Kindly, please. I
No.
have to dictate. Please keep it.
Will not be part heart.
Kindly keep it part of my lord.
Hopefully this bench will continue. So,
My lord, I humbly request, my lord. Whenever it lordship is, my lord, convenient, I said, my lord. Because one rhythm, like once I make service, my lord, sometimes what happens, my lord, technically.
the reason is that, you see, we're not sure about the bench constitution.
That's why I said, my lord, whenever lordship is, because I have got an argument with page marks. There's no difficulty.
No, I cannot say that this may be listed whenever this court is available.
But normally what happens, my lord, lordship is, I've seen, notice, my lord, after 2 weeks or 1 week, lordship, 2 weeks, 1 week gap is there, my lord. Lordship is going to Mizoram and other things, my lord. That's why I said, my lord, keep it part in any date, lordship, please. If on that particular day, order, your lordship is not here, we'll fix another date on that day, make a prayer. Automatically, you will not come in the list. We'll make a prayer and get it listed before you lost.
From 5th, you're not there.
My lord.
5th to 13, you're not available, or what?
Yeah, 12, 13, I'm available. I'm always available, except these particular dates, this holiday part.
The second week, this court may not be available.
Okay, my third week, I keep the lordship, my lord.
Third week, there's no roster, so I don't know.
My lord, keep it part hard, lordship may write whenever lordship sits, my lord, that will do.
No, keeping part hard will be a problem, Mr. Nath. We'll not keep it as part hard. If it's before the same bench again. it's
Next
well
week,
and
lordship is sitting in the next week, my lord.
Next week is what? The 3rd, 4th is there.
Oh, 4th, no, my lord, then.
That's what. Only 3 days. Only
days,
3
yes.
working days.
Yes. 12, 13, 14. March, any date, my lord. What happens, my lord? The lordship also knows. Once it changes, my lord, again from scratch, I have to start, my lord. And already I've started so many times in so many court. I got tired in this case, actually. I humbly pray, my lord, kindly.
What about Mr. Gogoi? You have no instructions from him.
Yes, Lord, on 10th of March.
12, I said, 12. I'll be out. Make it 12, if possible.
All right, as paid for by the parties, this is the matter on 12th of March 2026 for hearing. If bench is not available, then you have to continue with you have to start again.
Yeah, fresh.
Yes.
My lord, have mercy on me, my lord. Have mercy on me, please.
No,
My
you wanted 12, so we'll give you.
No, not. I said any day, lordship is sitting, my lord. Because she said the date 10th, I said 10th on Any date, my lord. Please, my lord, have some mercy, my lord.
I can't give you dates, actually.
Any date, my lord,
No.
my lord, whenever lordship sits, my lord. Whenever lordship sits, my lord. Any date, my lord, whenever lordship sits, my lord.
No, I don't have the dates with me, that's the thing. I don't know when this court is sitting again. This is the problem.
Now, normally what happens, my
And
lord?
this week court is here. Next
What,
week, we don't
normally
know.
what happens, my lord? Suppose in further matter date is fixed, in honorable court, the particular court is not there. What happens, my lord? It is not listed on that day. It comes whenever lordship comes back, my lord. That's the practice being followed. That's the way I see it, my lord.
will come probably March, after March.
Roster is not yet out,
Not
huh?
yet.
I don't know.
Say, whenever is it?
This week I'm here, next week perhaps.
Whenever
lordship
is here.
Huh?
See, lordship will sit, my lord. How we advocates on this side, my lord.
Third week of March, lordship may keep it third week of March, lordship, then if lordship available,
Not-
then. we will
Not
keep lordship.
possible. I'll keep it noted, but it may not be part heart.
Lordship.
This is the problem. So you take it on
I
12th,
leave to lordship, my lord. So,
not part heart.
it's up, it's up.
Okay.
Obliged.
Well, must. So, to give a date for the remaining case, I would like to raise.
Item number 30, my lord, may be fixed, my lord, next week, my lord, Tuesday, my lord.
My lord, I am going to file affidavit, my lord. Affidavit, and I
In
have
the
already
meantime,
sent
you
it to
can
the
file.
family, my lord. It may be come after 2 weeks, my lord.
My lord, date may be fixed, my lord, because it's a short matter involved, my lord. Because this issue is already decided by the Executive Council of the Dibrugarh University as to who should run the institution. My lord, this answer is in our favor, but then the formal permission is not been given, my lord, for shifting the location, my lord. That's the issue. My
Item
lord,
number,
My lord,
which item?
item 30, my lord.
30.
Yes.
Well, I have a prayer, my lord, in item 30. For respondent 5, my lord.
Yes, what is your prayer?
My lord, I want to file an additional affidavit in opposition. Some documents I have obtained very recently.
My lord, he has
In
filed
meantime.
2 affidavits.
In the meantime, I'll file.
Two additional affidavit already filed, my lord. My lord, affidavit in opposition.
My lord, some vital document which has been suppressed by the petitioner, I want to bring on. In the meantime, my lord.
Once for and all, my lord, that date may be fixed. In the meantime, they can file whatever they want, my lord. Because otherwise splitting is completed.
Okay.
After 3 weeks, your lord.
No. This fresh session is coming, B.Ed college, my lord. They are running illegally. Now fresh session, they want to take a chance.
Court master will give you a date.
My lord.
Check the
Yes.
diary. Check the diary. and-
Yes, we'll take. Obliged, my lord, deeply obliged. My lord.